for withdrawal, my lord. My lord,
Well, side.
original side, my lord.
Mention.
My lord, this matter was supposed to be listed on Tuesday, coming Tuesday. My lord, we have filed it today, but there are certain discrepancy in respect of the facts which we could find out yesterday. That is the reason we want to
Please
withdraw.
inform the other side also.
My lord, we have not served anything, my lord.
Well-
We are just, it has been the numbered 5 minutes back.
Yes, yes.
I'm grateful, my lord.
Personal appearance.
Oh.
Item number 1, personal appearance.
My lord, I am for the petitioner.
On behalf of the alleged contempt, my lord, he is personally present. My lord,
What was the alleged contempt?
the alleged contempt, my lord, for not supplying the police force?
Please come to the microphone.
My lord,
So Mahat, please come.
my
Yes.
lord, there are, my lord, the strength of the police force in the police, in the constant police station is lesser. So he, and my lord, also there is a direction of my lord that police cost be given. If the police cost is given, my lord, the requisition of more police will be available, and then my lord, the matter order, my lord's order will be complied
You
with.
could have informed that to the petitioner.
Yes, my lord, petitioner was requested to go to the police station for several times, but he did not go. My lord, these are the, my lord, the police called him on 3 times to go to the police station, so that the cost be. Now today, my lord, my learned friend is here. So let the, my lord, cost be
Please
deposited.
indicate the costs
Yes,
so
my
that the costs won't increase in the police station.
lord. My lord,
Please indicate the exact cost.
my lord, 30,000.
Why so much?
My lord, because of, my lord, the
How many personnel will be necessary?
necessary, because of 10 constable, 3 lady constable.
So what is your rate?
My lord, that is more than 1,500. And my lord, 1 inspector and 1 sub-inspector, and it has been written 5 ASI. 5 ASI, you will not be
So
necessary.
when would you like to pay the cost?
My lord, the private respondent has put a padlock, my lord, in the house of the petitioner.
That is why the police has been appointed. I mean,
Lordship, if the, my lord, there, if
in the cost, give me a date, give me a time. The police station will take the costs and they'll provide the police assistance. I'll fix the time.
Lordship, 4 days or 5 days, my lord, may be necessary.
Give me a specific date. Today we are on 11th. So so on 18th.
Yes, my lord. And before that, my lord, police will assist me to enter into the house, my lord.
You will first pay the costs. Otherwise, why will the police go?
If I could not
Cash
enter
is in
into
the
my
house.
Yes, my lord. The residential house, my lord. My lord, private respondents.
That as a citizen, Mr. Mahato, you should be.
Yes, my lord, that's
Let him enter his house.
This is, my lord, there is no information that is this type
Police,
of
police has
No, if
rescued
you
him,
have
my
to
lord.
inform the police authorities, how can they know that?
My lord, police has rescued him, my lord. Police knows everything. Who will,
Suomoto.
Suomoto FIR should have been lodged, my lord, because police has rescued and admitted.
You
him.
allege you have to lodge a complaint at least.
My lord, I have.
Several ways of
My lord,
lodging complaints.
I have lodged before the my lord, local, my lord, the landed court below, because police refused, my lord. Police rescued me from the spot and admitted me in the hospital. No Suomoto FIR, my lord. And my son, my
That
lord.
is beyond the scope of the present contempt. There was a specific direction of court. They have to comply it. Now the police says you have to deposit 30,000 because other extra forces will be necessary. Give me a date. I'll fix that date. You'll pay the cost. They'll give the assistance.
My learned friend is present, and he.
Yes, obviously, Mr. Shukla is there. So that
Only,
I
my
have
lord,
to.
by 18th I will pay, my lord, but before that police will, my lord, give assistance so that I can enter into my house.
Just ask your client to give assistance for entering his house, Mr. Mahato.
My lord, yes.
That is without cause. As a citizen, he is entitled.
My lord, he is entitled.
No,
My lord, but he has to intimate, but he is not cooperating.
no, my lord, that order was.
No, you have to go to the
that
police
notice was
station to
never served
intimate.
upon me, my lord. I am denying. My
Very
lord.
well, very well. At order record. Learned counsel for the alleged contempt submits that since the forces available in the local police station were not adequate to assist the petitioner, comma, further forces are required, comma, for which an approximate
But
police
it may be
cost
little
of
reduced, my lord.
rupees 30,000 is to be deposited. For sub next para, learned counsel for the petitioner submits that the petitioner is being prevented from entering his own house, comma, for which he is unable to pay such cash at the present moment, full stop, hence, comma, the alleged contemner is directed, the alleged contemner, that is the ASI of police and officer in charge of the Budbud police station, is directed to provide police assistance for the purpose of the petitioner entering into his own house. Full stop. Such assistance shall be provided by the police authorities as and when sought by the
Yes.
petitioner. Full stop. Next para. Upon such assistance being provided and the petitioner getting access to his house, comma, the petitioner shall pay the police costs of rupees 30,000 to the said police station. Full stop. The police shall comply with the order of this court and give assistance to the WBSCDCL personnel on the date appointed, comma, as per notice given by the WBSCDCL, comma, for the purpose of executing the order of this court. Full stop. Next para. A report in that regard shall be filed by the alleged contemner on the next returnable date. Full stop. It is expected that the petitioners shall deposit their police help costs within May 18, 2023, comma, upon which, comma, the WBSCTCL shall give the connection within a week thereafter upon prior notice to the police station as well as the petitioners. Full stop. The matter shall next be listed on June 7, 2023 at 2 p.m. Full stop. The personal appearance of the alleged contemner is dispensed with for the present, subject to further orders being passed on the next returnable date.
Petitioner in my learned friend client made today.
Tomorrow, my lord, tomorrow he will.
You will have to inform the police authorities when it's convenient.
So the petitioner is to be directed to intimate the payment of the cost to the WBCT itself. That is not found.
Very well. It is further clarified that upon deposit of the police costs, comma, the petitioner shall intimate about such payment to the WBSCTCL immediately to ensure compliance of the direction of this court.
My lord, I am making only one prayer, my lord. My lord, now it is admitted that as private respondent number 4 to 7 has interfered into the, my lord, compliance of this order, my lord. They may be implicated into the contempt of court.
Let us see above. First to get that connection, let us see.
And my lord, the cost.
Cannot add something on oral submission in a contempt application. You have to specifically allege. There is no allegation against the private respondents, only against the police.
Then I will prefer another application. In the
Don't.
next. My lord, kindly reduce the cost, my lord. Cost 30,000.
I don't have the power to decide.
Cost.
30,000 for so many people, yes, it's justified. 7th, it will be enlisted on 7th, Mr. Mahato. Personal appearance dispensed with for the present, subject to further orders.
My lord, my lord's order will be complied with fully.
Thank you so much.
I can assure you.
Thank you.
Lord.
Original side listed matter. Item number 1, Vritik Projects Private Limited, to be mentioned.
Section 11 application which we are opposing. Malad, we've got our notes ready. If not, we can just.
Please file, please. Both sides file their written notes of arguments. লিখছে? না, বুঝতে পারিনি। Both sides file their written notes of arguments. Na, ঠিক আছে। Hearing is concluded, judgment is reserved in the matter. I'll look into that.
And Malad,
Yes, Mr. Banerjee.
I'm sorry, Malad, this Malad, there's a bunch of judgments also. Malad.
Thank you.
Well, we have not referred to any new judgment, only those which have already been cited.
Thank you so much. You argued very well. Mr. Banerjee in general argues very well, but you have argued very well in this one.
No.
Keep it up.
No, that's the most encouraging Malad thing to hear, Malad, from the.
No, it should be. I mean,
But
should be
absolutely.
said when it is done.
Absolutely.
He argued so well, Mr. Banerjee.
Absolutely.
Thank you so much.
Grateful, Malad. Thank
Item number 2, Chandan Chatterjee and others versus Geeta
Yes,
Sundaram.
please.
Lordship, I'm for the petitioner. I'm being led by Mr. Krishna Chaudhary. Lordship, yesterday the matter was mentioned by my learned senior appearing for the respondents, seeking time for extension to file the written notes. Lordship was pleased to keep it
Monday.
Monday. Lordship.
Very well. let the matter stand over till May 15, 2023 for the purpose of filing of written notes of arguments.
Grateful, Lordship.
Thank you.
Item number 3, Archana Mishra and others versus Mrs. Bhagwalakshmi Nirmal Private Limited.
Pass over in the first call.
Item number 4, Water Tech Engineers Private Limited versus
My lord,
Yes,
the
Mr.
port
Ghosh.
trust, my lord.
My lord, I am for the petitioner, my lord.
Mr. Ghoshal, are you opposing this?
Yes, my lord, there is a very short point, my lord, I would like to, my lord, highlight, my lord.
Please indicate that so that you can argue on that also.
Only Lordship will kindly come at page 86.
Yes.
That is the claims, disputes and arbitration, my lord. That is clause L of the general
Mr.
conditions.
Ghoshal, please come a bit closer to the microphone. Yes.
General conditions of contract, my lord. Lordship will kindly see
Yes.
7.9.1, which they have referred as a part of the arbitration clause, my lord, which they have also narrated in paragraph 16 of their my lord, petition, my lord.
Right.
It says, my lord, there should be two stages that has to be, my lord, crossed before, my lord, referring it to the arbitration. First stage is within 30 days, the dispute has to be referred to the engineer. If the engineer's decision is they are dissatisfied, my lord, then it has to go before amicable settlement, my lord. Only after these two, my lord, steps fails, then only arbitration comes into play, my lord. My lord, admittedly, my lord, they have served a notice under 21, my lord, wherein, my lord, they have not.
Without exhausting this.
Yes. And, my lord, our reply to the notice, my lord, which is, my lord, at page 103, my lord. I'm sorry, my lord.
102.
102, my lord.
Hmm.
I'm sorry, my lord.
Hmm.
There, my lord, we had categorically, my lord, stated that, my lord, the first two, my lord, steps has to be, my lord, exhausted before coming. So this is perhaps a premature application, my lord. We are not against, my lord, in going for the matter in arbitration, my lord. Let them, my lord, come after, my lord, exhausting these two earlier phases as that has been prescribed under the clause, my lord. Only then, my lord, we are ready, my lord. We have nothing against going into arbitration or anything, my lord.
Right.
It may happen so that the decision of the engineer may go in their favor. We do not know, my lord. But they have
Let us
to
hear
exhaust.
Mr. Nosko on that. Yes.
My
Yes.
lord, we have been making
Mr.
communication.
Ghoshal, please take your seat. I'll just hear.
My lord, we have been making communication with the Port Trust Authority since, my lord, October 2020. My lord, repeated letters have been, my lord, served upon them. And, my lord, ultimately, my lord, finding no other remedy. And since there was, my lord,
Mr.
more
Nosko,
than
please show me the
70
letters.
my lord,
One or two of the
my lord, kindly sees the, my lord, invocation letter at page 91, my lord.
Where are the prior letters?
My lord, the prior letters
Have you
not been-
written ever to the engineer?
my lord, in my invocation notice, all the prior letters have been, my lord, referred.
That itself will not do.
That your lordship may
Anyway,
kindly
let us see the
consider.
invocation notice
Yes,
first.
my lord,
Yes.
at page 91, my lord. My lord, may I read the contents for your lordship's convenience?
Please.
My lord, this is to bring your kind notice as hereafter stated. Holdia Dock Complex, Kolkata Port Trust Engineering Department had published a notice to invite an tender number such and such for the design, supply, delivery, installation, testing and commissioning of 3 sets of 50 HP vertical tube turbine pumps along with suitable motors as per the technical specifications at the lock entrance of Holdia Dock Complex, Kolkata Port Trust. Considering the advertisement regarding soliciting tender applications, we showed our interest in the project. Thereafter, the Holdia Dock Complex authorities and our company, WaterTech Engineers Private Limited, entered into an agreement based on the letter of acceptance of bid, vidate number such and such, given on May 7, 2019 by such and such. After much persuasion, a letter of contract agreement was formally signed on March 10, 2020. Our company submitted a cross-sectional drawing for their approval with the bill material showing that bushes should be made of nitrile rubber in lieu of SS316 to avoid the galling effect. The original cross-sectional drawing of the existing pump submitted by you had the rubber bushes in metal shell, while in instant tender, Holdia Dock Complex authorities had mentioned the bushes made of SS316. We have received a reply through email from such and such
and Holdia Dock Complex authorities on August 24, 2019, confirming that nitrile rubber will not be allowed, as was claimed by us during submission of the detailed drawing towards manufacturing clearance. Under no circumstances will it deviate it from the provided details. That is, materials of construction of bushes should be SS 316 as per PO specifications. Revised sectional drawing was asked to be submitted for giving the approval in spite of us explaining the court as per the terms by the Holdia Dock Complex authorities that the pump will be engaged in dewatering activities under
Mr. Noskar
saline.
need not read the entire dispute.
My lord,
Just
then-
show me the reference to
my
the
lord, my
engineer.
lord, my lord,
Yes.
my lord. My lord, my lord, as suggested by my learned senior, my lord, I'm reading from para 20. Furthermore, all the queries from the Holdia Dock Complex authorities subsequent to this were aimed at delays and time period deviations, and never was this technical problem, the jamming and galling effect, mentioned anywhere. As there was a very strict lockdown and implementation of the Disaster Management Act, with arrests getting the required approval on behalf of the petitioner company's engineer, and servicemen got delayed as the region where Holdia Dock Complex authorities were located was cordoned off due to many COVID cases. We had repeatedly followed up with the Holdia Dock Complex authorities to sign the
Mr.
form.
Noskar, you have not invoked and you have not approached the engineer. Para 22 says that is the termination of the contract. Para 24 says you have invoked the arbitration clause. So
Precisely.
there is no engineer reference in the meantime. So you have to exhaust that and come. I'll reject with liberty to file afresh after you do that.
My lord, prior to that, my lord, then kindly, my lord, give me the liberty to file a supplementary affidavit. All the communications I will annex, your lordship may kindly consider then.
You have never mentioned in this section 21 at all that you have even intimated the engineer. You have to approach
But
the
my
engineer
lord, there
first.
are, my lord, it is my mistake that those letters are not part of this application. My lord, kindly give me the
It is
liberty.
not a part of the section 21 narration also. If it's not narrated here, how can we? It's not mentioned in your application. It's not narrated in the section 21 invocation.
My lord, there are several communications by and between the petitioner. and the-
Communications won't do, Mr. Noskar, because you
My lord,
obviously
requests.
communicated to the authorities,
My lord.
which led to the
My lord, my
termination,
lord,
which
my
you have mentioned here.
My lord,
So do that and come back.
my lord.
But this invocation is bad. So I cannot follow this up with a section 11 order.
My lord, if I am able to satisfy your lordship on the basis of the communications that have been made,
If you say on instruction, Mr. Noskar, that no, the engineer the matter dispute has been specifically referred to the engineer as contemplated in 7.91.1. That there has to be a reference to the engineer. Mr. Noskar, obviously, if it was referred, it would be with you.
my lord, let me come back, my lord.
Come
If-
back with what?
If there is any from the communications, if I, my lord, get a document that the district it has been referred to the engineer, my lord, if I am able to
A
satisfy
preliminary
your-
objection has been taken to the reference to arbitration by the respondent authorities. Full stop. Learned counsel for the respondent points out that in clause 7.91.1 of the concerned agreement containing the arbitration clause, comma, it was specifically mentioned that first the disputing party has to refer the dispute in writing to the engineer, full stop. Only upon such reference, comma, the party having any grievance with the decision of the engineer may approach the arbitrator. Full stop. However, comma, in the instant case, comma, no such prior action was taken by the petitioner, comma, thereby vitiating the invocation under section 21 of the Arbitration and Conciliation Act 1996. Full stop. Hence, comma, the present application is premature. Full stop. Next para. Learned counsel appearing for the petitioner seeks an adjournment to take instruction and to produce relevant document, comma, if any, comma, indicating that the matter was previously referred to the engineer in compliance with clause 7.91.1. Full stop. For such purpose, the matter is adjourned till May 15, 2023, when it will be listed under the same heading for the purpose of production of further documents by the petitioner in that regard, comma, if any. Full stop. The learned advocate on record for the petitioner shall hand over advance copies of the documents sought to be relied on, comma, if any, comma, to the learned advocate on record for the respondent prior to the next returnable date.
Deeply obliged. I appear along with Mr. Jaina, my lord.
How dare you?
Old practice, my lord. Always do this.
Adjourn motion, item number 5, Nilab Joshikdar versus Tata Housing Development Company Limited.
Yes,
The application under section 11, but there is an issue involved, my lord, which requires some consideration, my lord. That venue clause issue.
Ah,
My lord. So, my lord, I would be only praying this, my lord, that let me come ready with some.
whenever you say,
There's only another point that I want to point, the issue I want to point out,
indicate that so that you can.
which is a bigger issue, bigger than the venue, and that's the document on the basis which the application has been filed, the unstamped document.
Ah,
Now
No,
the
but
judgment has come.
now
It's an
we are
agreement for-
on the basis of the conveyance.
No, filed on the
The
basis of the
agreement
agreement for
for-
sale.
so that's the point he has indicated, Mr. Shin, you have to
Yes,
take care of that.
I've
also.
taken that point in the opposition.
Can't take care of it properly, then it will be impounded and then.
I'll also
He can't
clarify to
impound
my
it.
learned
He
friend.
can't impound it because he already it is registered.
I'll also, that is what I'll already clarify with to my
He
learned
can't-
friend. There is
It's
an
registered already.
The
conveyance is
agreement for
registered.
sale
There
is
is an
there.
arbitration clause in
The-
the conveyance.
Right, but he invoked the clause in the agreement for sale, which is unregistered. So that now he cannot say that that he can't.
Mr. Shin, now you are aware of this point, so
I-
come
I-
ready
I-
on this one.
So
So I'll keep it when? Tell me.
After vacation. my lord. One,
You're for the petitioner.
I am for the petition.
Very well. On the prayer of learned counsel for the petitioner, the matter is adjourned till after the upcoming summer vacation. Full stop. The matter shall next be listed in the monthly list of June 2023. The list will be short, so.
Yes.
only one kindly record that we are seeking your early disposal of this application. That kindly that recording be there. That's
Very good.
That's my suggestion.
It may be noted that learned counsel for the respondent opposes the prayer for adjournment on the ground of urgency. That's this much.
Grateful.
1 week, no mood to go into so much of law now. my lord. Tremendous law, my lord, and complicated.
I fully agree, Mr. Shen. Fully agree with
The
you.
different courts have taken different views on this, my lord. So I will
No, on this also.
on the
that
venue
before-
clause.
No, on the issue that there should not be any detailed consideration of. No, before 1 week up before the vacation.
That is a consensus view.
That is a consensus.
That's
It has to be. Very
of
well.
like-
Please come.
Item number 6, Shrey Equipment Finance Limited. versus
My
Equipment-
application.
Yes,
I'm
Mr. Len-
little out of time with the reply. It's ready. I can serve him today and file it also. Thereafter, Lordship fixes it any day, my lord.
After vacation.
Why after vacation?
I may concede, my lord. So keeps it this side of the vacation, my lord. I may concede to this. No, no, I
No,
will,
no, no. Let him take.
I will talk to my client.
We have to cross these stages before that. So very well. The delay in filing the affidavit in reply is condoned, and the affidavit in reply filed today in court be kept on record. Full stop. A
Give the
copy thereof be served.
I have served.
Is served here and now on the learned advocate for the respondent. Full stop. Let the matter stand over till Monday.
My lord, makes it Tuesday, my lord.
Tuesday. Very well.
Tuesday. Great.
Stand over till May 16, 2023, when it will be listed under the same heading.
Grateful, my lord. Deeply.
Passover matter. Item number 3,
None appears even on the second call. Let the matter stand adjourned for the day. Complete হয়ে গেছে তাহলে appeal set. এইটা তাহলে একটা অর্ডার রেকর্ড করুন ওই এটা none appears even on the second call. Full stop. Let the matter stand adjourned till next কবে matter আছে 15th. Adjourned till May 15, 2023. তাহলে কালকে বসতে হবে না urgency. Appellate said matters, no? Yes. Not regular officers to give us some time. Mr. Ghosh.
Item number 2.
Yes.
Appellate side matters.
Well, this is my application.
Yes, please.
My lord,
No time, apart from adjournment, whatever else.
Mr. Kaur is leading me in this matter, and that he is on his legs. Can this matter be taken up on Monday or tomorrow, any day?
If it continues for some time, Mr. Ghosh, I don't know. I mean, whatever you say.
Huh?
I can keep it on Monday also. I have no difficulty, but otherwise, if you have any difficulty, I can take it up today also.
He's on his legs, I keep it on Monday.
Very well. On the prayer of the WBSCTCL, the matter is adjourned till May 15, 2020. Ready. নামগুলো একটু নিন।
Item number 3.
This matter, I appear on behalf of WBSCTCL.
Yes.
On the last occasion, there was a direction to serve copy. I have taken instruction, but
So, copy of what?
of the writ petition. I have taken instruction, but
You concede?
in respect of, there are two demands which we have made. This is in respect of the wires.
Lord, may I place my case before?
I think that will be better. No, let her place her case.
My lord,
Because it will take
I
some
was-
time to place your case.
I was playing, if may kindly take it up on Monday, because
Why Monday? Come back tomorrow.
My Lord,
No.
already on the last occasion, your lordship had asked them
My lord-
not to take further time. Very short issue, my lord.
this is not, there is.
What is the dispute about? Let us hear her. Yes.
My lord, the very dispute is very minor, my lord. Since 2018, we are requesting them that the very lane which joins the state highway to our compounds, my lord, there are 9 writ petitioners before your lordship. My lord, to our warehouse compound, my lord, all the vehicles that are bringing in goods to our compounds, my lord, are being obstructed and hindered by the conductors which are hanging from the 2 sides of the road, my lord. And my lord, basically, my lord, as per rule 77 of the electricity rules, my lord, there is a standard height prescribed. My lord, these wires or cables, my lord, they are hanging much below that height. And my lord, every time these vehicles which come to our compound, my lord, bringing our goods, my
There's a
lord,
risk. Hazard.
yes, my lord. My lord, we have even, my lord, since 2018, we are communicating to them. They have responded to us once saying that in 2018, after the festive seasons are over, my lord, they will take steps. My lord, thereafter, they kept
So
quiet.
what happened during this period?
Now,
COVID.
all of a sudden, my lord, in 2021, from my lord, from a blue moon, they come up with a demand that in order to lift the height of these conductors, my lord, public conductors, they have only installed. We need to pay them.
Why, Mr. Mukherjee?
This is a wrong submission, my lord.
What is
Because
the right submission?
first of all, there are 9 petitioners, but only 1 has applied, other 8 has not applied. Only
Then if one applies, it's your duty, safety.
yes, my lord, we in 2022 has already done our job, my lord. Subsequent to that, again, respondent number, petitioner number 9 has applied, my lord. And in respect of that, there is a consent letter. My lord,
One
which,
signed. One signed. The present
Yes.
petitioner signed.
yes, my lord, that is, my lord.
I'll direct a short affidavit. You have all the papers. File it on Tuesday.
My lord, not on Tuesday, my lord, keep it after.
Wednesday?
Keep
No,
it
not after vacation, Mr. Mukherjee. No.
My lord,
This is going on for quite some time. If it's a safety hazard, Mr.
No,
Mukherjee,
no.
there is some urgency.
My lord, only 1 day has been given, my lord, where I have asked for the copy.
I'm
My lord,
giving you more than that.
my lord,
Today
kindly,
we are on Thursday,
Yes.
so you'll get till next, say, Tuesday.
my lord, kindly
5 days, no?
My lord, kindly make it after.
You have got all the papers.
My lord, there are certain instruction which I need. My lord,
Ji,
my lord,
There is nothing else on in this. But the only urgency is it's a safety issue.
Well,
If it's really a hazard, then we have to take immediate steps.
my lord,
Mr.
there are 2 aspects. We have raised 2 demands. One is in respect of upliftment of the wires. Second is their in respect of their application for shifting. But the shifting, my lord, we have already.
Regarding lifting the wires,
Yes.
why should you ask
That
for
is-
charges?
My lord, that is the reason, my lord, I was praying before my learned.
Come with instructions on Monday then. Or tomorrow, why not? Take your instructions, your WBSCTCL.
When I keep it on Monday, manner, then I'll come, because that was the question which were hovering my mind. That is the reason I was submitting that. My lord,
You
kindly
are
keep it-
also asking for a shifting.
Yes,
Kindly take page 34 and 35, my lord. They have given us 2 quotations only for.
Now, where is your application or representation?
My lord,
That is
we
not-
have written several representations.
there
and
is no
Show me one.
My lord, lastly, by advocate's letter on 30, my lord, at page 36. Lord, this is the last representation, and from page 18 to 31, my lord, we have enclosed more or less all the representations even made by, my lord, their customer care service.
my lord, keep it on the reopening day. I will file affidavits.
Show me one, Mr. Mukherjee, where it is stated that they require a shifting. Show me one.
That is not there. We have issued two things. Kindly come to page 34.
Increase the height, Mr. Mukherjee. nothing.
Kindly come to page 34. There are two demands. One is in respect of low tension overhead
Your
line.
demands are getting.
There are two lines which is there. One is high tension line, one is low tension line.
Why should they pay? It's a safety hazard. You have to take care of the licensee.
I appreciate, that is the reason, I on the first go I was about to
Don't pay
submit
only lip service to your appreciation, Mr. Mukherjee. Just implement that appreciation also.
keep it on Monday or give me a chance to file an affidavit and keep it on the reopening day.
No. Question of affidavit then. They are asking now she's submitting, your friend is submitting that they are wanting only the increase of the height beyond the statutory level. So do it. I'll direct you to do it. Do it and come back on Tuesday with a report that you have done it.
This is a long stretch of land, that is the difficulty.
How long? You could not do it in 5 years.
No, we have already done it in 2022. That is my specific instruction, pursuant to their representation.
Every
we have
time
done
it happens, Mr. Mukherjee, you have to do it again. This is not a one-time thing. If it comes down, you have to put it up again.
I bow down to
so your upliftment, they need not pay for your upliftment of the WBACD sale.
I bow down to that also.
You have to uplift yourselves.
Kindly keep it on Tuesday. I'll come back with instructions.
Learned counsel for the petitioner submits that despite repeated representations being given by the petitioner since the year 2018, the WBACDCL has not taken any steps for increasing the height of those are the conductors
Wires, cables.
of wires and other electrical equipment, which are owned by the licensee stroke WBACDCL, even above the statutory height as stipulated in the law and the concerned rules.
77 of
I'll just keep it vague for the time being. They are also saying shifting. Let us look into that. Full stop. Next para. Learned counsel appearing for the WBACDCL submits that such correctional work was done by the WBACDCL in the year 2022. Full stop. Subsequently, the petitioner is seeking the same work to be done again. Full stop. Next para. It is argued that the WBACDCL is required to look into the matter and come back with proper instructions. Full stop. It is further submitted by the WBACDCL that the said licensee has claimed costs for twofold work, one for lifting the height of the equipment and the wire, and secondly for the purpose of shifting the same to some other area. Full stop. It is prima facie clear that it is the responsibility of the licensee to take care of its own equipment and gadgets, including wires. Full stop. It is the lookout of the licensee solely to ensure that there are no safety hazards to the people in the locality due to non-compliance of the rules and regulations in that regard. Full stop. Next para. However, on the prayer of the WBACDCL, the matter is adjourned till May 16, 2023, when the WBACDCL, through counsel, shall file a brief report indicating as to what work has been done with regard to the complaint made by the petitioner, as well as indicate the exact expenses and the head for such expenses required for such task. Full stop. It is made clear that the liability to pay prima facie is on the licensee. Full stop. However, such question is kept open for being argued by the WBACDCL when the matter is next taken up for hearing.
I'm grateful.
Short report, what work you have already done and what are the costs, under what head.
I'm grateful.
And it has to be very specific, Mr. Mukherjee, nothing technical so that I don't understand. Either shifting or increasing the height or upliftment or whatever.
I'm grateful.
Thank you. 4.
Item number 4, I am praying for only not today.
Not granted. Move the matter.
I am not the advocate on record, my lord. Mr. Varko Chakraborty is appearing, my lord. He has not come to
on the prayer of the petitioner. The matter is adjourned for
only on day, my lord. Today.
Only
day's accommodation.
Adjourned for the day.
Item number 5.
I am for the petition.
I am for the CA.
Usual combination. Yes.
Lordship, this is my affidavit of service. returned as insufficient address, Lordship.
You're managing the post office or something, Mr.
No,
Halder,
no,
in
but,
every matter, none of the
Private
respondents are-
respondent is managing because he is the father of the petitioner, stays in the same premises and returned
Father
as.
son dispute, my
If
lord.
you could manage you, Mr. Halder, your client, then he could manage this also.
Lordship, kindly sees the annexure.
Insufficient address.
Lordship, father of the petitioner. He is objecting the connection. I तो जानी letter of objection আছে তো
Yes. Yes, what do you say?
My lord, we could not hold the inspection itself because the father objected.
Why, on what ground is he objecting?
He doesn't want the son to get the, it's a dispute between the two of them.
What is the nature of the dispute? Be frank.
Lordship, then I have to take instruction on
Take
that
instruction, come back tomorrow.
tomorrow, Lordship.
Grateful.
Learned counsel for the petitioner submits that the private respondent, comma, being the father of the petitioner, comma, is resisting electricity connection from being given in the name of the petitioner at the premises. Full stop, the affidavit of service filed today in court is kept on record. Full stop. It is evident from the same that the postal endorsement indicates that there was insufficient address mentioned on the envelope. Full stop. However, comma, the petitioner submits that the private respondent, within bracket father of the petitioner, bracket closed, lives in the same premises and the petitioner, comma, which address was mentioned in the envelope. Full stop. Be that as it may, comma, the petitioner is directed to disclose as to what is the exact nature of objection of the private respondent to his taking electricity connection. Full stop. For such purpose, comma, the matter is adjourned till tomorrow.
Lordship, only Lordship kindly sees the annexure. The CSC authority has received the letter of objection. But
What does it say?
they have not handed over, but the.
If you have the letter of objection,
They can-
please bring that tomorrow. I'm not recording that, but please bring that.
Good.
Thank you.
Item number 6.
6, yes. Yes, Mr.
I am for the petition, Lordship. Lordship, this case relates to theft
As
of
your lordship
electricity.
says, again, a typical combination.
Typical combination.
I am praying for let the
You are
matter.
not typically, you are rarer.
I am rarer, no doubt about it.
Really.
You are more senior.
I know.
Lordship, I am praying for let the matter be redirected to.
Nothing in the matter, absolutely nothing.
No, my lord.
Theft of
Absolute.
electricity.
I do not agree with my
Why
lord.
should it be referred to the Lok Adalat at all? What is the matter about?
Theft of electricity.
Why should we? Lok Adalat cannot decide.
No, they cannot decide.
Oh, it's
the-
compoundable. They can decide. They can
Lord,
decide.
As I said, my lord, typical of my learned friend's position here, this petition hides more than what it has shown. Let me place the facts as they exist, my lord. Can we take the petition for a moment? Page 3, para 8.
Yes.
Your petitioner state that the CAC authority never made any allegation or complaint against your petitioners regarding their supply of before disconnection. Incorrect. By his own submission. Kindly come to para 12 and 13, my lord. This contradicts his own argument. Para 12. Your petitioner state that thereafter your petitioner received a provisional order of assessment dated so and so. And on 13, also received the final order of assessment. So how can he say that he is not aware of what has happened? How can he say that? There is first a provisional order of assessment. There is a final order of assessment. I mean, my humble submission here is my learned friend is aware of the provisions of law. It's not that it's falling from the sky. He's aware of it. He's aware of the fact that section 127 will stare at him in the face. So what does he do? He is filing a writ petition after the statutory period of 30 days. And this is not the first time that this has happened. I will only beseech your lordship not to encourage these kind of things. My lord, I can understand that, yes, there is a monetary consideration that may be involved, but I think as far as we counsel are concerned, the legal conduct must take precedence. No doubt about it, my lord. He cannot keep filing these kind of petitions and take an encouragement and an indulgence from the court, say, please go back to the ombudsman, let the ombudsman decide. That can't happen, my lord. But 127 is very specific to say that you have to file your appeal or against that order within 30 days.
Mr. Halder, I can leave the scope before both of you, I mean, before you actually, to have it compounded if they agree,
Lordship,
before the appropriate forum.
Lordship,
But this dispute cannot be decided by the
That's
local
right.
authority.
And
No,
127 is very
If the court can't, then the local adalat's power will be the same. Because you have not challenged the arrest or the offense.
No, we have already taken bail before the division bench, and Lordship, we have deposited
Get
50%.
it compounded.
Lordship, that's
what
why
I
we
am
are,
saying
we are
is,
referring the matter to
this
the
is-
Lok Adalat.
From the next time, Mr. Halder, please indicate to me what is the nature of dispute also, even in Lok Adalat matters. This cannot be decided by the court. So how can I refer to the court, Lok Adalat even?
If the amount is settled, Lok Adalat will.
Vimla, the
we
amount
can-
is settled. There is a final order of assessment. And
There
the
is
law
scope of further settlement, Lordship.
Mr. Lal, then I'll record your submissions on the suppression also,
That's
as well as your submission that you are not agreeable to this reference to Lok Adalat also.
Absolutely.
On the ground which you stated.
127 is very clear and
127
specific.
is there.
You have to deposit the entire amount.
If both sides don't agree, Mr. Halder, I can't refer it like that. Just
If-
like that, I feel.
And even the 50% that my learned friend is talking about, that is a subject matter of a criminal appeal, anticipatory bail. And that order was that it will be without prejudice to the rights and contention of both the parties. But that was in an anticipatory bail matter.
Lordship, in several
127
matters, Lordship has redirected the matters to Lok Adalat.
Well, I am objecting here because let him pay the full amount. He is accepting the fact that yes, there is a proof-in threat. He's on record to say so. So where is the question of any further adjudication of the amount?
Very well. No reference, Mr. Halder.
Lordship, then kindly give 1 day time, Lordship.
Senior Mr. Halder will come.
No, Lordship, kindly
Adjust.
adjust.
Difference, Mr. Halder. Once
Kindly
you
adjust
express
the matter for the day, Lordship. Kindly.
Why? Why? For what?
Then I have to take instruction whether he will pay the entire amount.
He has to. It's not a question of taking instruction.
Very well.
Because he is ready to go before the Lok Adalat.
At the outset, the petitioner submits that the matter be referred to the Lok Adalat, full stop. However, learned counsel for the CSC argues that several points have been suppressed, several facts have been suppressed in the writ petition. Full stop. There is a contradiction, comma, it is submitted, comma, between the averments made by the petitioner himself in paragraphs 8 and 12 of the writ petition. 8, 12 and 13 of the writ petition, comma, where in one breath, comma, the petitioner submits that the CSC authority never made any previous complaint against the petitioner, and in the other, comma, that the
Lordship,
petitioner,
may I interrupt, Lordship?
that the
for-
petitioners received provisional and final orders of assessment. Yes.
Lordship, in paragraph 8, we have stated that the petitioner never made any, CSC authority never made any allegation
Before
such-
disconnection.
before such disconnection, but the provisional bill and final bill we have received after disconnection, Lordship.
Full stop. Next para, learned counsel for the petitioner, comma, however, disputes such contention and argues that the said bills were received after the disconnection took effect. Full stop. Next para, be that as it may, comma, since the CSC Limited has expressed through counsel that the CSC Limited is not agreeable to an amicable resolution in the matter before the Lok Adalat, unless the petitioner takes due steps under section 127 of the Electricity Act 2003 and stroke or deposits the balance amount of assessed charges, comma, such reference cannot be directed at the present moment, full stop, on the prayer of learned counsel for the petitioner to enable him to take instructions from his client as regards whether the petitioner is agreeable to deposit the balance amount, comma, the matter is adjourned for the day and shall be listed under the same heading tomorrow.
Good. May I have your Lord's leave to appear virtually to comment on this matter?
Very
Objection.
Good.
এরপর যেটা আছে সেটাই দেখুন, যা আছে সেটাই সেই অর্ডারই দেখুন।
Item number 7, Parthad.
Madam, the petitioner, may I file my supplementary affidavit pursuant to your lordship's earlier directions?
Yes.
Number one prayer I do have, if you lordship.
Yes, Mr. Padayachari.
Thanks enough, your lordship. Milord, I have received a supplementary affidavit by learned friend. Now, Milord, I am wish to file a reply on that. It is ready. If your lordship give me only 2 days time or 3 days time, in the meantime, I will file.
Very A supplementary affidavit is filed today pursuant to previous leave granted by court and be kept on record. Full stop. Learned counsel for the WBSCDCL. For the WBSCDCL seeks 2 days adjournment to file rejoinder thereto. Full stop. Accordingly, the WBSCDCL is directed to file the rejoinder on May 15, 2023, when the matter shall next be listed. Full stop. It is expected that an advance, not 15th. It is expected that an advance copy of the rejoinder shall be served on the learned advocate for the petitioner prior to the matter next being taken up. Should I keep it on 16th? That will be easier for you to give a copy to him. 17th? 17th?
কেন আমি আমি থাক- আমি 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 থাকবো না ম্যাটার দিস ইজ নট দ্য ওয়ে
No, 17th is solid. Successful, Mr. Pomader. 15th না করে 17th করে। Thank you.
usually I don't like to disturb this court unnecessary but
Usually you don't know.
lordship right.
Item number 8.
Yes. This is the second occasion when none appears for the parties when the matter is called on for hearing. Accordingly, WPA 27077 of 2006 is dismissed for default without any orders to cost. Interim order, if any, stands vacated.
Item number 9.
My lord, I appear for the authorities. My lord, this was with relation to enemy property. Mr. Basu was appearing. He wanted to address your lordship. My lord, on the point of maintainability, I had indicated that under 18C, there is a central government. They can go before the central government, and I had relied on decisions of coordinate bench of Justice Rajashekhar Mantha, Justice Banerjee, and Justice Ghosh.
Right.
My lord, he was supposed to get back with the with some citations, my lord, to overcome that.
Mr. Basu means which Mr. Basu?
Mr. Shaptangshu Basu.
Shaptangshu Basu. So he's not there.
When Mr. Basu is leading me, my lord, I am ready with the answer. My lord, I leave it to you.
Very well. Mr. Banerjee is there with the answer, so let us hear him.
Yes, my lord. My lord, only thing I was proposing, my lord, the rate is of 2006. My lord, there has been orders which has been passed post 2006, and much water has flown since 2006. If I can put in a supplementary affidavit bringing on record as to what has happened post 2006, my lord, it would be much better for adjudication of this matter.
Now,
But-
Mr. Bhattacharya, 2 orders have been handed over to me. If it is, if there is something else, you can. February 11th, 2022, and prior
Yes,
to
my lord, 2 more things which I wanted to add.
Yes.
One is the authorization order under section 8 of the enemy property, my lord, issued by the,
Bhattacharya, how soon can you file your affidavit?
my lord, let it be on the reopening, my lord. It's been 2006 and your lordship knows how the government functions, my lord.
Very well, very well.
Uh, a week after the reopening, I will do it.
No, no, not a week.
My lord, typically 3 days. At least 3 days after the
You will file your supplementary affidavit, Mr. Bhattacharya. We are reopening on June 5th. So you will file by June 7th. Rather, it,
my lord, kindly makes it 8.
Pardon?
My lord, kindly makes it 8th of June.
8th?
8th, yes.
Very well. So you'll file your rejoinder if any, Mr. Banerjee. if
One
it's
week.
one
But
week.
my lord will kindly, my lord, make these directions peremptory because, my lord, for 1.5 decade, my lord, I am not being able to use my property. Because of
2006 it is pending without being included in the list. So we are also guilty for that. I cannot castigate myself. for
No,
this.
no, kindly have a look at, my lord, the order sheet. My lord, the Union of India, my lord, prayed for, my lord, adjournments
Very
on, my
well.
lord, several occasions.
On the prayer of learned counsel for the Union of India, the matter is adjourned till June 15, 2023. Full stop. The prayer of the Union of India to file a supplementary affidavit is granted. Full stop. Such supplementary affidavit containing certain subsequent developments and relevant papers in connection therewith shall be filed by June 8, 2023. Reply, if any, shall be filed on the next reopening, on the next date of hearing.
Grateful, my lord.
Then, yes.
My lord, these directions be peremptory.
Yes, yes, my lord.
These are peremptory directions, Mr.
My lord,
Bhattacharya.
my lord, my lord, my lord.
Take this back. Put this in your rejoinder report. এগুলো একটু ফেরত দিয়ে দেবেন ওকে আর এটা নিচে রেখে পরেরটা ডাব থ্যাংক ইউ Grateful. Mr. Banerjee, please remind me on the next occasion that these were peremptory. If
And
I am still
wish I
there.
remember.
Thank you.
Item number 10.
10. আপনি একটু পারলে মাইক্রোফোনে বলুন আপনি খুব ভদ্রভাবে আসছেন বলছে একটু শুনতে হবে আইটেম 10 yes
Item number 10.
ওই একই অর্ডার এর আগেরটা যেটা হলো none appears even on the second none appears for the parties. This is the second such occasion. Accordingly, WPA 27100 of 2006 dismissed for default without any orders to cost. Interim order, if any, stands vacant.
Item number 11.
Same. After vacation or before vacation?
Item number 12.
Lordship,
After or
uh,
before vacation?
After vacation, Lordship,
You're for the?
petitioner, Your Lordship, this brief has come to us just now, Lordship. We are yet to collate the document. We're not able to.
Very
take
well. On the
records.
prayer of the petitioner, the matter is adjourned and shall next be listed in the monthly list of June 2023.
Obliged, Lordship.
Please give your appearance, ma'am, so that we can bind you on the next occasion when I dismiss for default.
Item number 13.
13.
Please, Your Lordship.
Yes, please. Virus.
Virus. I have gone through my Lord's judgment, Abdul Mateen. I have gone through the two Gujarat High Court Division Bench judgments.
Have you gone through the judgments which were quoted in my judgment?
Yes.
Those are more important. Yes.
Few points still survive, but I must be candid to Your Lordship. I have made, my Lord, a gist of the points. I'm handing them up, my Lord. I've done.
Give a copy to him also, Mr.
Yeah.
Naik.
আমি একটু এটা নিয়ে নেবো, আপনাকে এখানে দিচ্ছি, হ্যাঁ? বড় একটা কপি আমি দিয়ে দিচ্ছি।
Should we continue after recess? I mean, it's 1:13 now.
Will Your Lordship take it up on Monday?
No, no.
Oh, Your Lordship wants to take it up?
Oh, definitely.
Fair. No, I'm ready. I'm armed.
Yes,
I'm
yes. And you complete your arguments in 15 minutes after recess.
Well, I have not yet started.
That's why.
In this, I have not started, my Lord.
That's why. If you had started, Mr. Banerjee, then 2 minutes. Your notes are very significant and please stick to these.
Fair. No, I can't assure of the 15 minutes, but I'll stick to the notes. I'll stick to the notes. I'm
The
not
first bell. We'll continue after the recess.
Your Lordship, item 28 of today's list, Your Lordship, in the second half, I have a doctor's appointment, so I was mentioning this
Ask any
matter.
of your friends to be there. Ask for an adjournment. I'll definitely run it. এটা এখন রেখে দিন, দুটোর পর এটা দিয়ে শুরু করবো। বুঝছেন? তোমার ওপরেই রেখে দিলে পারতেন ওর নামাজে। Yes, Mr. Banerjee.
Yes. Now, my lord, I've tried to make it as short as possible.
No,
I
no,
thought
make
the
sure.
virus part, I know, my lord, repeated arguments on the question of virus of two constitutional provisions.
Right.
When decided upon by 3 benches, is, my lord, a very cantankerous proposition. I will not, my lord, venture into going into the forensics of what has been decided. I find, my lord, certain portions after, my lord, studying in my own way, my lord, Abdul Mateen, if your lordship kindly takes up just once Abdul Mateen, which your lordship was pleased to decide, and the 2 judgments of the Gujarat High Court, which are cited there, considered there. Abdul Mateen, the points that were cited before your lordship, Lord, I'll just try to summarize in about 3 minutes. Give me 3 minutes, Lord, and I'll try and argue out of those points and not those points. Kindly takes up, my lord, paragraph 2, just the brief points.
Yes.
Argued that 126(1), my lord, I'm not placing 126, 135, all that, my lord has seen on a number of occasions. Straight away to the point. Argued that 126(1) provides for a mere provisional assessment, which, however, is conclusive as to the allegation of theft of electricity against the accused, without granting the accused person any opportunity of hearing. Such serious allegation, which is a stigma and has far-reaching criminal consequences against the accused persons as well, is thus examined and decided by the same person who gave the report. There is no trial before a competent judicial forum with due opportunity of leading evidence and cross-examination being given to the accused. Thus, it is argued the said section is violative of 1921 of the Constitution of India, is thus ultra-vires the Constitution. This can be straight away, my lord, answered by saying that the Supreme Court has explained in Sitaram Mills that 126 is has a different field of operation, 135 a different one. By making you liable to make charges in terms of 126, it is not necessarily being held that you have committed theft. There may be a subset, there may be a set which is outside the set of theft, which can come under 126. There can be an overlap, and then for the overlap, 135 and 126 are there. 135 deals with the offense of theft, which is tried by an appropriate court. So there is no question of your being heard, condemned, unheard, and the like. That's the first point raised. Second point is 4, though paragraph 3, such assessment both at the provisional and the final stage are done by the assessing officer, who's generally an employee of the distribution licensee. It is the same officer who submits a report on inspection as to the unauthorized use of electricity by the consumer or person concerned, and thereafter assesses the amount chargeable as electricity dues. Again, the same officer hears the person concerned and arrives at the final assessment. Thus, it is argued the assessing officer, who's an employee of the licensee, acts as the judge, jury, and the executioner. Final order is a merely mechanical reiteration of the provisional order of assessment without any independent application of mind or examination worth its name. Although labeled as assessment orders, no reasons are given. That's the third. Absence of reasons. My lord, kindly come to paragraph 5. Makes appeal provided under 127 a farce because he does not have a proper opportunity to represent his case before the first forum. 6 is 50% of the total assessed amount, which may be exorbitant, arbitrary, makes, my lord, the provision of appeal illusory under 127. And in 135, counsel of the petitioner next argues that section 135 of the Act provides for criminal proceedings before a special court. However, the definition of theft in the said section and that of unauthorized use in section 126 overlap largely, particularly insofar as the allegation of tampering of meter is concerned. As a consequence, the licensees can pick and choose to enforce different penal consequences against persons accused of the same or similar offences at their own sweet whims. The consequences range between payment of huge sums of money and disconnection of electricity, as well as imprisonment and/or fine. Hence, it is argued section 135, which provides for the harsher punishment, ought to be struck down as ultra-vires. This is regarding 135. My lord has answered all this. Just now come to the next point, which was raised before your lordship. 12 speaks of Article 14, paragraph 12. Kindly come to my lord. Article 14.
Yes.
in its application to legal proceedings, everyone should be assured the same rules of evidence and mode of procedure. So this is what was urged before your lordship. 14, everyone should have a right to have the mode of evidence and the mode of procedure. And if not, it is violative of Article 14. Then my lord, paragraph 13, 135(1) of the Act is ultra vires, as Article 19(1)(g) is violated due to unbridled power being conferred on the licensee authority to invoke the provisions of 126 or the provisions of 135 of the Act in case of theft or pilferage of electricity, as also unauthorized use of electricity, depending on the color of the hair of the consumer. So you can pick and choose either 126 or 135, and therefore 135 is ultra vires. And it's also ultra vires, my lord, the provisions of Article 19(1)(g) of the Constitution of India, in a manner which has not been argued or explained in the argument at paragraph 13. Now, thereafter, kindly come to 16. Recovery of citing an unreported judgment of coordinate bench, learned counsel reiterates the proposition. Proposition being that in previous paragraph 15, to argue that civil liability determined by the special court is dependent upon the criminal liability only upon the order of assessment being finally passed and served upon the consumer is expected to pay the charges. 17, placing reliance on judgment of JTG, argues that cases of theft falling under the ambit of section 135 do not have applicability of 126. That's again not a point of virus. Kerala State Electricity Board, Supreme Court reiterated that section 126 is intended to cover.
Many judgments were cited there, Mr. Banerjee, which were not relevant at all.
I have
they were cited. I had
cited. Your lordship had to just include them.
Yes.
As far as an attack to virus is concerned, the only worthy attack to virus which I find 126 was the initial part where they say that in 126 unbridled power has been given, but then that has not been developed on further. Unbridled. From there, they have gone on to 19(1)(g). 19(1)(g) has no manner of application there. 135, they have gone on to the question of 135 is ultra vires because one can pick and choose either 126 or 135. After Sitaram, that is no longer, my lord, a point which can be argued. So really, my lord, those points. What I'm trying to show before your lordship is perhaps not the best assistance was rendered at the bar when your lordship was requested, my lord, requested to go into the constitutional validity of these two provisions. There are other aspects which are beyond the scope of what has been argued here, which are present, which can also form plinths of attack, my lord. And I would want to develop only those. Now, my lord, just going further into my lord judgment again, 18, 19, Article 21, consumers' right to access civil courts. Then there's something challenging the ouster jurisdiction of civil courts. All that
comes to your points directly, Mr.
Decided, yes. Now, my lord, my points.
I'll proceed on the presumption that these were not argued or dealt with.
Yes, I have tried to, my lord, make absolutely sure that they have not been replicated. But I did not have, my lord, at my disposal the first of the two Gujarat division benches. So, my lord, I had your lordship's order and the second Gujarat division bench of Justice, my lord, Pardiwala, Justice Bhaskar Bhattacharya sitting with Justice Pardiwala, where the first one has been recited, portions of it extracted. I don't have the first one. So I take it that the portions extracted were the relevant parts, my lord, of that judgment. Now, my lord, 126, my lord, if your lordship kindly sees it from the conspectus of an impost. My lord, the citizen cannot be made to pay a single rupee unless there is a binding contract or unless there is a provision of law. This is well settled. There are judgments for that, for each proposition, but I will not try and give judgments for well settled propositions. It's only where the dispute crops up. A citizen cannot be.
Sweet money is not legal, that's why.
Yes. They've made it legal. In Walmart, if your lordship sees the balance sheets, there is a heading, lobbying charges, and they show it in their audits. I asked one of my clients who came to me with some Walmart accounts, and I asked them, what is this lobbying charges? They said exactly what you interpret to be lobbying charges. And I said, you're showing that in your balance sheet? He said, yes. It's a business contingency. We're showing it in a balance.
In certain temples, if you pay more, you can get to the
direct access
Lord
to God.
quicker.
Direct access to God. Yes, that happens, my lord.
Get to his or her ladyship or lordship quicker.
Kamakha, my lord, my lord.
Not only Kamakha. There
Kamakha,
are
my lord,
north, south, east, west.
My parents-in-law paid more, but then, my lord, my side of the gate was empty.
That was probably charged because they were your parents-in-law. You must have spoken too much there, Mr. Bennett. Obviously, that was the.
Now, my lord, kindly comes, my lord, to this is the proposition which I'm trying to develop, which I have not found there argued either before your lordship or before my lord in the Gujarat bench. Now, my lord, a citizen, even if he has to pay a single rupee, has to pay it under a contract or under a provision of law. If the payment has to be under the provision of law, then it has to be of the nature of a compulsory exaction of money. It can be in the form of a tax, in the form of a charge, in the form of a fee. Earlier, we used to have these watertight divisions between taxes and fees, tax being to the general pool of society at large and the state at large, not against any particular service. Fees being quid pro quo as against a particular service. But then there are dilutions in both now. Fees need not be quid pro quo, absolutely, and taxes need not be that, absolutely. So these lines have now become blurrer, my lord. More democracy progresses, the more walls collapse. Now, in this impost at 126, there has to be a charging section, there has to be an assessment section, and there has to be a recovery section. No impost ever under any statute. One is contract. Let us say I am in a contract with a person X, which might be an Article 12 authority also, or might be a private person. I am under an obligation to make X amount. If X is not paid, then that contract can be enforced in an appropriate forum. That's one, but I'm out of that. Let's consider the second aspect. The second is an impost, which is a non-contractual based impost. So it has to be an impost based on statute. Statute means it has to be an impost based on parent legislation or direct legislation. That impost cannot spring out of a subordinate legislation. The manner of calculation can come out from subordinate legislation, but the impost has to spring from direct legislation. Now, my lord, if your lordship looks at the Electricity Act, your lordship will be pleased to find that there are various provisions or chapters, my lord, of the Electricity Act. My lord has discussed that also in the Abdul Mateen judgment. Kindly come to part 12. This is the part on assessment.
It starts from which section, Mr.
126 itself, part 12.
Oh, right. Yes.
Investigation and enforcement is the heading of the part. Assessment is the heading, my lord, of 126. So, my lord, this one thing is apparent from a bare reading, even if my lord, before taking your lordship into other portions, is that this is the second limb of the impost. This is not the first limb. The first limb has to be charging, the charging section. Then there has to be a computation, assessment. Then there has to be a recovery. These are the three means, three modes. If all three modes are not present, then it will not be a compulsory exaction worth its name. Now, in 126, kindly be satisfied when I submit from a reading of this that this is for the purpose of realizing the amount towards electricity charges payable by a person who has not paid because of the fiction that happens of unauthorized use. That's the concept. Kindly come to 126.1. If on an inspection of any place or premises or after inspection of the equipment, gadgets, machines, devices found connected or used, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited under by such use. Now, my lord, so he shall provisionally assess. This is the second stage. So where is the charging section of this? Charging section, if your lordship considers, maybe section 45. It's like 170 of the KMC Act. The section which says that we have a power to recover these charges. That's the charging section. The substantive power injected into the statute. 45, subject to the provisions of this section, the prices to be charged by a distribution licensee for the supply of electricity by him in pursuance of section 43 shall be in accordance with such tariffs fixed from time to time and conditions of his license. This is 45. 43 is the duty to supply. 44 is the exception from duty to supply. 45 is the charging section for the quid pro quo. Now, charges for electricity supplied by distribution licensee shall be A, fixed in accordance with the methods and principles of the concerned state commission, published in such manner, etc. Charges for electricity supplied by distribution licensee may include a fixed charge in addition to the charge for the actual electricity supplied. B, a rent or other charges in respect of any electric meter or electrical plant provided by the distribution licensee. Subject to the provisions of Section 62, in fixing charges under this section, a distribution licensee shall not show undue preference to any person or persons. Charges fixed by the distribution licensee shall be in accordance with the provisions of this Act and the regulations made in this behalf by the concerned state commission. 45 is the charging section. In 126, you are recovering electricity charges. Kindly be satisfied when I submit that 126 is not penal in nature.
No sanction as such.
126 does not impose a stigma. Complete wrong argument came at the bar. I won't say wrong.
Stigma in any event it does not, but there is no sanction provided in 126 itself.
It's itself also. Now, my lord, argument at the bar, my lord, advanced in Abdul Mateen was that a stigma is caused by 126 because it's
Obviously not relevant.
No. Now, kindly come to this. 126 is a simpliciter payment of charges which ought to have come to the person, which has not come by virtue of a fiction called unauthorized use. What are the elements of the fiction? They are defined. What can be unauthorized use? 45 is the charging section of 126. If 126 is used for the purpose of collecting charges, it can never be more than what actually would be the charges under 45. Please test this proposition and please, my lord, express the gravest doubt. But please test this proposition because on this base, a building will come up.
So this read with 126 also, subsection 6.
6
that
times
says twice the time.
That is where I'm saying that it's wrong. How I'm slowly building it up and coming to manifest arbitrariness. Lord, Article 14, that sort of Article 14 cases placed before your lordship or placed before the Honorable Division Bench of the Gujarat High Court were the slightly older Article 14 cases in which, of course, they are invaluable even now, in which there's a question of there being two classes being separable by intelligible differentia, which has an object with the next.
More in black and white.
Yes. Subsequent Article 14 cases, apart from this, has gone into arbitrariness itself as a substantive doctrine. Arbitrariness started with arbitrariness of executive action. Then it slowly reared its head into arbitrariness of legislative action as well. And now the doctrine of manifest arbitrariness has been developed. It's been recognized by Justice Nariman even in those triple talaq cases and the like. Doctrine of manifest arbitrariness of the legislature. Now, for that arbitrariness to be manifest, it is not something. It's not like Wednesbury or unreasonableness.
But regarding arbitrariness of legislature, we have to be very cautious so that we don't violate the separation of powers.
Yes,
so
but
we have
yes,
to be cautious on that.
Yes, legislature has the right to legislate.
Because they represent the people.
Yes,
they voted. I mean.
Yes, voted in indirect representation. So it's the people who's making the law.
Which we don't.
Yeah, but looking at arbitrariness still, arbitrariness has been separately carved out as a plinth. The only new terminology is the verbiage is manifest arbitrariness. By manifest, it's not extreme. Manifest means apparent. Yes. Something which does not require too much argument to bring out.
True.
Something which may not require traveling out of the statute to bring out. Now, my lord, manifest arbitrariness on that plinth, kindly once examine the proposition again. 45 is the charging section for charges. Had there been no 45, they would not have been able to charge the consumer a single rupee for servicing electricity. It's an essential service. The duty comes first and then just deserts for the duty. That also.
Mr. Banerjee, section 45 says clearly that this is the charging section vis-a-vis section 43. Because the very first subsection says, subject to provisions of this section, the prices to be charged by a distribution licensee for the supply of electricity by him in pursuance of section 43 shall be in accordance with such tariffs fixed from time to time and conditions of his license. Now, this is the regular electricity charges payable for section 43. But what is the bar in introducing a penal element in this also, 126? I mean, is it a straitjacket formula that it's either has to be penal, or because there may be several elements in this 126?
No, if it is the penalty, if it is a penalty,
yes,
then if it is a penalty, it has to come under offenses and penalties.
Why does it have to be restricted to section 45? That is my question actually. I mean, why not beyond that? 126 itself has certain charging components, twice and all these things.
Now, would your lordship, no, that's again, I've told you, lordship, but there are three components. One is the levy, second is the assessment, third is the recovery. That section starts with the word assessment.
Yes.
So it's the second component. What is given here, my lord, is not a component of a levy. What's given here, my lord, is a machination to arrive at the figure.
But assessment, the caption of the section, Mr. Banerjee, is at best an intrinsic aid. I mean, we should look into it only when there is an ambiguity in the section.
Yes.
Where is the ambiguity in the provision?
No, every taxing statute anywhere, every taxing statute anywhere in India, if your lordship looks into, your lordship will have to find a levy, have to find an assessment, and have to find a collection. What I am initially suggesting is that the 126 is not the levy. It's not the levy. It's not the charge. It's not the levy. The levy, the power to tax, the power to extract monetarily, compulsorily monetary extraction power comes under 45.
Very well.
Now kindly come to 126. 126 gives this gentleman the power to fix a charge.
Or the lady.
Or the lady, the power to fix a charge. And there's absolutely nothing saying as to how that power will be used. Different from the income tax escape assessment. My lord went into that in Abdul Mateen. The income tax escape assessment is they get hold of certain details from where a figure is available to them. They tell you to explain. You can't explain.
That was in the context of the citation.
Yes. So this is different from here. Kindly see here.
No, I don't understand this logic of yours because 5 and 6 are there. Subsections 5 and 6.
Kindly see 5 and 6, what 5 and 6 says.
Let us see that also, yes.
If the assessing officer reaches the conclusion that unauthorized use of electricity has taken place, so that's a condition precedent, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. It's a timeline. Charging. How does one make the assessment, my lord? All these hows are present in the substantive statute itself. That is the biggest feature of a fiscal enactment, be it of the nature of a charge, a fee, a tax, or the like.
Material basis is there in 6 also.
How does one charge? Let us say, my lord, I am, my lord, the officer charged on whom the power coupled with duty has been given, my lord, under the provisions of 126(1). What do? I don't have subordinate legislation to help me. Because, my lord, lordship is looking at manifest arbitrariness. Lordship will not go into any other thing for the time being. Then test it when they show it. My lord, my lord, I am the officer. What do I do?
So are you suggesting that there is no power? I mean, there is no scope of no other section which gives the power, which empowers the officer to charge this, because this is neither electricity charges nor a penal provision.
I am submitting that the three things have to be absolutely certain. One is levy. Levy is certain. 45 engulfs everything. Levy is certain. Second, assessment. Third, recovery. How they can recover? There are provisions for recovery also. That's certain. How? Public demands recovery, XYZ, ABCD. I am on B. If B is deficient, my lord, B is deficient, A and C together do not make a charging
Be
marriage.
deficient, why do you say that?
Because
On the anvil of 45.
Now, be deficient in his own anvil. Touch, kindly test B as a, kindly consider your lordship to be an assessing officer. Not kindly pardon me, pardon that the instance.
Well, I often feel like that. When in some of the subject matters of the challenges, I often feel like Panchayat, occasionally Panchayat, alternatively Panchayat and assessing. So there's no difficulty on that.
Kindly, my lord, considers that lordship, there is a proposition that a statute has now told your lordship, my lord, to make an inspection and to see whether there's unauthorized use of electricity. A conclusion has been arrived at 126.4 that there has been an unauthorized use of electricity. 126.5.
126.1.
Yes. Now, what will be done? Kindly forget levy. Kindly forget levy. Kindly forget recovery. These two are disjoint. One is not dependent on the other. If you have a weak levy, you can't boost it by improved assessment and the like. All three limbs have to be self-sustaining, muscular, organic limbs. You kindly look at 2, dehors 1 and 3. 3 is recovery, 1 is levy, 2 is assessment. What will your lordship do? I'm asking myself the question.
Answer it also.
My lord?
Answer it also.
Answer is, as per the statute, your lordship can do nothing.
Because there is no charging section. No.
There is no modus. A modus has to be there, my lord, in every fiscal statute. GST, income tax, direct taxation, indirect taxation, formulae are there, percentages are there. It's a mathematical statute. All these fiscal statutes are mathematical.
You are on the basis of the mathematics. Mathematics is there in 6.
There is no mathematics in 6.
Come to
yes.
6 once.
Kindly see.
Yes.
Yes.
5 and 6, let us read jointly.
Yes.
First 5. 5 you read the first limb of it. There is a second limb also. However, the period during which.
If you can't ascertain the period.
Ascertain, yes.
Whole year. Otherwise, the period.
Right. And 6 says that will be twice the tariff.
That will be twice the tariff applicable for the relevant category of services specified in subsection 5.
Tariff is chargeable under 45.
45. It will be twice the tariff. I have a separate attack there. It can't, it's beyond the levy, but that's a separate attack.
This is not a levy. This is for unauthorized use.
This is
a separate different component.
No, it might be a component. For that, there is if there is a penal element to it, that's covered under 135. Kindly look at 126 as a separate first of all a separate fiscal provision. Lord, we will go into the question of the other aspects of it slightly later. Now, assessment. I am saying please assess this on the basis of 126.5. Your Lordship, I have been unable to do it.
I still don't understand. My limitation, but I don't.
No. Kindly, my lord, see, unauthorized use of electricity by any artificial means.
Yes. Let us take one. Inspection. First component is there has to be an unauthorized use.
You find an artificial means being used.
Whatever means that is detected. That is then specifically prescribed.
Then you have to assess.
Right.
How do you assess?
5 and 6. Why not?
What does 5 say?
A modality has been given. A modality has been given.
5 is a fiction regarding the outer limit of number of days. Nothing to do with the modality. Kindly, my lord, correct me if I'm wrong.
6.
Rate. Double the rate. It was 1.5.
Exactly mean by modality which is divorced from the rate and the way in which it will be calculated.
A formula. You are when you're extracting money from a citizen, a reasonable formula. A formula, not even a reasonable, a formula.
Can we go look into the legislation so much? I mean, such a deep inquiry.
Fiscal, yes. Penal, yes.
This is per se. This is not a fiscal statute.
No, but this is a fiscal provision.
Fiscal
provision. Lordship will employ fiscal construction norms here. The moment Lordship is employing fiscal construction norms here. For instance, my lord, the KMC Act. I keep on saying KMC because that, my lord, it's
on this.
More or less this. Every part of it is, my lord, defined. There is an annual valuation. There's a method to arrive at an annual valuation. Method is expected annual rental for 12 months minus 10% is the maintenance. That gives your lordship the annual valuation.
So here also, why can't we say 5 and 6 provide a method and I mean, that's the method and methodology or whatever.
Using 5 and 6 alone, in the case of explanation B1, please come to a figure.
The figure can be derived at, see, Mr. Banerjee, there are two components of this. 5 says, suppose there are two possible situations. One is that it can be defined that this is the entire period. Then that period's tariff has to be taken. That has to be doubled, and that will be the charge leviable. And if it cannot be ascertained, the period during which it was defective or theft was going on, now then it has to be, some fiction has to be brought in. If it cannot be ascertained exactly how long it was being stolen, such period shall be limited to a period of 12 months immediately preceding the date of inspection. So it's very specified. The inspection today, I find out that there is a theft, pilferage, unauthorized use is there, not theft, actually unauthorized use. And I have to calculate on the basis premise of the previous 12 months, what will be the calculation at a rate equal to twice the tariff applicable. The tariff is very well, I mean, supported by section 45. 45 gives the power to levy tariff. You get the tariff.
So one of the indicia I have got, one of the elements I have got.
Tariff I have got, and it's twice that. Now, if you say twice is a draconian thing or twice, that's there, Mr. Banerjee, probably we cannot trade in. Because if the legislature being the representative of the people think twice is a logical thing, unless you could show any other index to show that this is palpable, no, this is not on an equivalent footing. The other statute says this, no, it cannot be double. It can be 3/4 or 1/3 or whatever. I mean, legislature in its wisdom says it should be twice the tariff. Tariff you get by calculating the previous preceding 12 months, simply. That is sufficient. So where is the question of any ambiguity in this?
The only ambiguity, my lord, if your lordship kindly sees, is the lack.
It's all a jargon you are using, Mr. Banerjee.
I'm trying to break it. I'm trying to break it.
It's the ambiguity.
I'm trying to break it.
Let us proceed on the language of the statute.
Of the statute itself. My lord, kindly,
very clear. 5 and 6 are very, very clear. You may say that's an unreasonable basis.
That's the second line of challenge. But then this is not inbuilt here.
A very, very, very tricky situation for you, because there I have my doubts how far we can go into it unless it's palpably manifest arbitrariness or something.
Because into 365 is a huge proposition that would take my appeal out of contention straight away. But I'll come to that later, much later. Presently, my lord, if the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection.
As simple as that.
Now, my lord, it takes into account, my lord, a fiction of 12 months when you can't ascertain the actual period. What would be, my lord, the other components, my lord, which would make me arrive at that figure, that rupees?
What is the other component required? Merely the number of months?
Voltage and amperage.
You say those criteria are not there.
That those criteria may be there in certain cases, may not be required in certain cases.
The regulations clarify those also. They say 3 months prior, and other aspects are there also.
But your lordship is examining the statute. Your lordship is looking at the statute. 126, my lord, is looking at the statute. Subsequently,
so specific as regards all the indexes, all the indicia or whatever you say. I mean, may not be. It gives the basic modality. The modality is given. Modality is that it has to be based. Tariff is a basis, which is not an unreasonable basis. Tariff, the usual tariff, which is used by the which is paid by the consumer. So the tariff is a reasonable basis. Why not?
Yes, the tariff is a reasonable basis. I mean, the tariff is one of the available objective ingredients. The other available objective ingredient is the length of days. If it is not ascertainable, then it comes to a fiction of 365. Puts in a huge multiplier. So it becomes, if done within a day prior, but it cannot be actually ascertained.
It may be 366 also probably, because if there's a leap year.
Leap year, it may
12 years preceding.
12
So
year
if that
proceedings,
takes care account of one leap year
one extra
February,
day, then it may be
then maybe
366
6 also.
So, my lord, even more hardship.
Yes,
Now, my lord,
harsher by 1 day.
harsher by 1 day. Now, my lord, coming back to this formulation has to be there in the parent statute. This formulation cannot be outside the parent statute.
These are for people like me, Mr. Banerjee, who are not very good in maths. So it's very easy to calculate 12 months. 12 months into what is the criterion? The tariff for 12 months into 2. That's an as easy calculation as can be. So where is the ambiguity in it? Where is the question of there being no assessment, proper assessment provided for? This is the modality. Sufficient modality. Legislature thought that is sufficient. Why should I interfere that sitting in this AC room as a judge? I feel that I should do it, and therefore I go as an itinerant of justice as per Justice Krishna.
No. Well, that was not the aim. The aim was to bring home the point that in case of a fiscal provision, the entire shell of that calculation and computation in assessment proceedings will have to be there in the parent statute, lodged in the parent statute.
This is the parent statute.
And the entire shell. What are the multipliers that your lordship will take into consideration
What
here?
else is required? It's 2 for all cases.
Your lordship is also required to consider amperage voltage. Your lordship is required to consider
tariff answers for all those criteria. The tariff.
Therefore, my lord, at a given point of time, let us say, my lord, when there has been tampering of a meter and the meter cannot be read, and one goes and finds that the meter is defective, and one finds that it has been done manually. How does, my lord, one calculate the charges?
Apply 5 and 6. Apply 5 and 6. Simple. Where is the ambiguity?
The ambiguity is, my lord, that there's no. The ambiguity would be something where there's a doubt. There's a gray area. I am saying that the elements are not there. The elements are not there. My lord, I had made a computation, my lord, I've tried to put 5 or 6 or 7 statutes and the manner in which the charges are calculated there. The lordship will find that.
Mr. Banerjee, can you show me there are two different ways in which this calculation can be applied in a single instance? I mean, if that is so, then there may be an ambiguity. I mean, this calculation applying 5 and 6, there may be 2 calculations, 2 sum totals which are coming by applying the same calculations in the same instance.
I get your lordship. That means that.
So where is that? I mean, if there is only, suppose I take a single instance, there can only be a single sum which we arrive at by applying 5 and 6. So if that be so, where is the question of any doubt or gray area or whatever?
No, my lord,
I don't find any gray area in this. It's very simple.
So
you may have some doubts regarding the tariff being twice the quantum, etc. These we have odd doubts, but majority wins. Legislature is the majority. They have legislated. Unless it's palpably manifestly. Yes.
Now,
this is not manifest.
The manifest thing is 365. That's the
365
manifest.
days, yes.
No,
not 365, as I said, 12 months.
12 months.
12 months.
12
May
months.
not be 365.
That's the manifest thing, my lord. For a days.
Anyway, Mr. Banerjee, that is just a nuance of that modality.
No, that fiction lends it, my lord. What does that fiction lend it? Kindly look at the fiction now. That fiction lends it the capacity of getting it multiplied by 10.
Why? How?
The figure multiplied by 10. If from yesterday something has happened as a result of which the CSC was required to have tariff amount X, which it has lost or foregone from yesterday. Today, when that inspection is made, if it is not ascertainable, then straight away, my lord, into 12 will be the total amount.
Some amount of guesswork has to be brought in, Mr. Banerjee. Otherwise, how can you deal with this? Give me an alternative. Give me an alternative. Suppose it cannot be ascertained for what period pilferage was going on or unauthorized use was going on. So what will be a yardstick? A yardstick. Whatever you apply, that will be a reasonable guesswork. And reasonable guesswork is permitted even in alimony orders.
Yes.
So if that's permissible, if we are permitted, the legislature is.
Then 1/3 to 1/5, we always keep by that law.
We used to before 1997-77.
Now, Lord.
Anyway, but Mr. Banerjee, this is not a very strong argument.
This part, Lord, I would still like, Lord, to your lordship, Lord, to
better go. I'll have it assigned before a fiscal judge. And who deals with Justice Nizamuddin will be the perfect. So you can impress upon his lordship probably, but I am not impressed because I am I have not dealt with revenue matters previously.
No,
Probably
revenue,
that is
my
one
lord,
of the-
I have brought, my lord, I have brought.
Probably
judgments.
that may be one of the reasons, Mr. Banerjee, but I don't find anything wrong in this. I mean,
No, the only thing I'm
nothing
trying to,
manifestly.
the only thing I'm trying to tell you, lordship, is this.
Yes.
The submission is this.
Yes.
In any provision in which there's a compulsory exaction, every part of it has to be calculable from the body of the section.
This is calculable. Why not calculable? The number of months is given 12 months. The tariff is the tariff is a basis. Tariff has to be doubled. This is the calculation. Entire calculation lies there. So where is the question of any ambiguity, or if you don't want to use the word ambiguity,
I'm saying
there is
that
any doubt?
lack of elements for the purpose of making an objective assessment are not there.
It's elementary, my dear Mr. Vanes. It's elementary. It has to be elementary. Too many elements spoil the section. Because too many elements, if it is provided in the statute itself, the statute will be as bulky as our cause lists. It will be as bulky and as difficult to interpret. As difficult. Because we have to care for all situations. We cannot provide that in a statute. I mean, the statute can only provide for the basic guidelines. Basic elements have to be there.
No.
But after that, it's left to the commissions and all these authorities.
For them
For
to
the
make
nitty-gritty, yes.
Look, that's
So
all.
this is probably not a very strong logic.
Now, subject,
despite your good English.
Subject to bringing, my lord.
Some of the words I could not understand, but I pretended to understand. But the basic tenor I understand, Mr. Banerjee. What you are telling.
Now, lordship is telling
like impost. Basic tenor I have understood. There is no difficulty in that. So, what is the next point? What is the next?
This point, though, my lord, unsuccessfully argued now.
Not yet.
I would try to, my lord, create a plinth on this because this is a hugely important point. I mean, I'll tell you, lordship, why it's hugely important.
Superstructure falls, Mr. Banerjee.
Plinth on that superstructure falls. There are other plinth works also remaining.
What are the others?
The others, my lord, I'm coming to. This one is important because this one, my lord, I'll have to provide you, lordship, my lord, tangible examples. Otherwise, my lord, it might not really come out. The second, the other limb, my lord, of challenge, my lord, which I had put in is that if everything is ascertainable, my lord, why base judgment? Please, my lord, kindly bear with me.
I raise argument. Come on.
In my naivety.
Very well.
Kindly.
No, not in your naivety, in your flair for English. This is becoming an English language class, Mr. Banerjee.
Lord, I shall come back, Lord.
On the statute, a layman has to understand the statute. That is the basic premise.
Yes. Lord, as far as the second point is concerned, my point was, my lord, in 126, there is really no guideline given for the best judgment to be exercised.
If there was, then why would it be a best judgment?
Base judgment is
the
required.
best of his judgment would become meaningless then.
No, base judgment, I'll tell you, lordship, would be required in cases like the Income Tax Act, where my lord had dealt with there, my lord, in that Matin case, where there is an element of presumption required, of an element of.
Mr. Banerjee, you have a point there. If it was only base judgment, then definitely you could have had a point there. But here one has to be read with 5 and 6.
Circumscription. The 6 is circumscription. So I give up.
No.
Milord,
judgment, the modality of that assessment has been given in 5 and 6.
Two parameters have been given, 2 indicia. The entire modality is missing. There, your lordship is not with me, but kindly for the sake of argument, assume that the entire modality is not there. A person concerned is given, my lord, something to do on his best judgment. What does he do on that best judgment? Income tax matters, my lord, I have seen, and I'll bring those. I have brought those, but instead of trying to multiply submissions and making it long and arduous, I was trying to make a table. Your lordship will see best judgment comes in at a time where the manner in which to catch the escaped assessment is mentioned. That's there in the statute.
Mr. Banerjee, we have to go on the presumption. We have to look into explanation A also of subsection 6.
Yes.
An assessing officer is not a layman like you and me who don't know anything about electricity probably. I don't
Yes.
know about you. I can speak for myself.
No, no, regarding electricity, except for operating AC is nothing else.
Assessing officer means an officer of a state government or board or licensee, as the case may be designated as such by the state government.
My lord.
Now, he or she has to be a technical person, definitely.
Yes.
If he or she is a technical person, they go there and they see, they have an inspection, they find that these devices are there. And what is the magnitude of that pilferage or unauthorized use, that they have to ascertain on the basis of this. He is on the field or she is on the field. Standing there, he or she is assessing on the basis of the equipments, gadgets, machines, what is the magnitude of that unauthorized use. And after that, he is assessing according to his or her best judgment. Now that is the best judgment.
This were so, my lord, in the statute,
Yes.
then, my lord, my challenge to this limb of challenge would immediately be cut off. But kindly see, this is not there. The first part of your lordship's observation.
Why do you say that? Let us read
Your
one.
lordship has observed saying,
Hmm.
there he goes to the spot, he uses gadgetry to find
No,
out.
He inspects the gadgetry.
There
He's a technical person. He
there-
uses the best gadgetry available to him.
That's Mostishko. That's the Mogojastru.
And that he applies and he finds out, because he's a technical person, everything, the technical knowledge is in his mind.
Yes.
So he or she assesses on the basis of an inspection of the equipment, gadgets, machines, devices found connected or used.
Yes.
If a dynamo is connected there,
Yes.
and if a small device is connected, there's a difference between the two. So that will be his or her best judgment assessment.
Now, this
That
base
is the
judgment
reason for
assessment is a technical assessment.
True.
It's a technical
Best
assessment.
judgment has to be technical.
And technical assessment has technical assessment of varying parameters, amplitudes, varying amplitudes, my lord. Technical assessments of varying amplitudes, not provided for in the statute.
Achha, theek hai, very good.
Not provided for in the same authority who did it. That point has been exhausted,
But
my lord. In the judgment.
Mr. Banerjee, then it had to be, this section would be at least 5 or 6 pages, and each of the sections probably theft, 135, 126.
My lord, I'll tell you, lordship.
This is not a taxi statute.
Kindly bear
as
with me.
such.
The moment you decide that you're going to take money from the citizen, it's a completely different ballgame altogether. As long as it's something different, it's beneficial, other provisions of the statute, etc. Moment you say it's penal, and the moment you say it's fiscal, there are certain elements, there are certain parts of the Bible you have to write.
Very well. You say the basic elements are missing in this. What will be the criteria, the yardsticks for this assessment as a whole?
For this
Only
assessment
base
as a whole.
judgment, tariff,
Only base
and
judgment,
twice.
upper limit of the number of days, and that too, my lord, the number of days is something which gives a huge negative impact on the SSE. If it can't be ascertained, it will straight away be that number of months. That will balloon the provisional order of assessment by 10 to 12 times. And that will be 50% of that will be payable for the
You are
purpose.
correct on this, because I'm hearing these matters now. Now, one correct assessment, I mean, one correct submission of yours is, it might have been better. Why I say this? It might have been, if it's not ascertainable, only then the problem comes in. If it's not ascertainable, why arbitrarily 1 year? It should have been, you can say that it should have been the date of inspection and the previous last inspection of the meter.
Yes.
That could have been a criterion, which should be much more reasonable. But on that anvil, can you strike down a provision?
Yes, in fiscal, I'll tell you, lordship, why?
That is my idea of a good provision.
That is what
your idea of a good provision.
But can the court under Article 226 do that? The answer is, if it is a fiscal statute and if it has the effect of destroying everything, what is it destroying? My lord, kindly see it the other way around. What is it destroying?
Very well.
It's destroying, my lord, the assessment order. Destroying in strong language, but my lord, because of that multiplier, it's destroying the assessment order. It's blowing it out of proportion. It's destroying the 50% of that which I have to put in as a precondition to my appeal.
The entire thing, the superstructure, as you said.
127 I can't approach, and therefore I am left with the proposition of staring at him and trying to and succumbing.
Very well. Very well.
Now, my lord, this was, my lord, my second point. I would not also try to develop that a bit. 126 is there. Kusum ingots has been, my lord, cited before your lordship. Kusum ingots contains a paragraph which gives to Article 226(2), which has not been given by the Constitution. I would request your lordship, I have come up with 8 or 9 very very fundamental judgments on precedent law. That single liner of Kusum Ingots is really takes away territorial supremacy, my lord, of the high courts, saying that if there is a central cause of action and if any one limb of the cause of action arises within the territorial jurisdiction of the high court, that court would have jurisdiction to take up a writ petition on that cause of action, even though it has been located largely outly beyond. That is one thing. But trying to read that as a corollary and saying that Article 226(2) means that a judgment delivered by another court of law on the constitutionality of a central provision.
But that is still there. I cannot distinguish Kusum Ingots.
Kusum is.
I'm not qualified to distinguish Kusum Ingots.
Kusum, I examined it, found it.
Sitting as a single judge of a high court, can I?
You found it with, found it, my lord, within.
That is there. That is there. That is there. We have to proceed on that premise.
That part of that
part of that interpretation of Kusum Ingots. We cannot deviate from that. How can I? I cannot.
If it's a stray, my lord, or not a stray observation, not my lord, founded.
It was not a stray observation.
226 was considered.
Anyway, let us not be so academic. Let us finish the matter. Yes.
Kusum will come to my lord later. My lord, before that, my lord, only one thing.
I had said 50, not 50, but it's already 50.
It's already 50.
But
But I will.
short.
My lord,
Make your arguments.
I'll do one.
So this is a good discussion. Make your argument.
Yes, I'll finish it. But my lord, I would want a buffered day.
Don't wait. No, don't wait till I am convinced, Mr. Banerjee. I won't be convinced sitting in court. I'll be convinced only when I go through the matter at more of a length.
Deeper length.
Deeper length, deeper light, more length. You make your arguments. We'll argue on this, but let us finish this over.
You also want to finish it today. I
absolutely today.
I badly, my lord, with all the humility at my command, want to, my lord, finish it a day later.
Let us continue, Mr. Banerjee.
Yes, we will. I'll finish. I'll finish for today. But a day later for your lordship, my lord, when your lordship comes back to just show your lordship.
Not for one electricity matter, no. Even if you challenge a 5 days, no.
There are two matters, my lord. So by your lordship's definition, my lord, I get another.
By two. It gets lesser. Yes.
Now, my lord, kindly, my lord, my basic challenge, my lord, if your lordship kindly sees, my lord.
So one is regarding the assessment part you are saying, and 126(1) you are saying.
126(6)
Twice.
Is beyond the scope of the levy.
Beyond the scope of the
levy.
Very well.
So 126(6)
Levy as in
is
45.
ultra-virus. Beyond the scope of the levy.
Wait for the effect, Mr. Banerjee. Continue.
One 126(5) is a dangerous and impermissible statutory fiction. This, my lord, I have argued, in fact. This is part of that argument, my lord. I kindly see Roman 13 of page 3. The effects I have mentioned. Effects ABCD. Please not go through 13 once. I'll not dilate on 13 too much.
Very well. Yes, maybe.
Roman 14. In any fiscal law, 3 components. Assessment,
that also
not complete. না ওটা তো ডিল করে দিয়েছে গুজরাটের জাজমেন্ট হলো ডেল্ট Lord, while on this, Lord, may I just go back to your lordship's judgment?
Need not. For what purpose?
No, then, my lord, I just wanted to finish it in this way. I just wanted to show your lordship, my lord, the manifest arbitrariness doctrine and to the elements of that doctrine so that we can tick the boxes later. Can I show your lordship, my lord, the manifest arbitrariness doctrine under Article 14? What has been shown to your lordship, my lord, is the Ajay Hasia Khalid Musib.
Show that.
Last বলে দিয়েছিলাম ওইটা বের করে 11:8.
It would be better, Mr. Banerjee, if you gave me the relevant paragraphs of these judgments, if you can. If you can confine your judgments at page 5 of your arguments.
And the ones that I've given there, no?
The ones that you.
Yes. I'll be giving that.
That would be a bit better for me. At least the broadly relevant
Paragraphs. Yes. Kindly come to 2011-8 SCC, page 737 at page 767. Here I am a bit handicapped also.
You have not put this in your written notes.
No, actually, I had looked at another set of reports. Now this is SCC. So that's the whole difficulty. I had looked up the Indian Kanun version, made notes on that.
No, this you have given. The next page, page 6, additional judgment. Should I look into any particular paragraphs or?
Kindly see 50 at Roman 8. আছে আরেকটা আছে তো আচ্ছা ঠিক আছে আপনাকে আমি শেয়ার করছি ঠিক আছে তুমি রেফারটা আমাকে লিখে দাও দিয়ে 8 is legislative arbitrariness. In Ajay Hasia versus Khalid Mujib Sehrawardi, this court held that Article 14 strikes at arbitrariness because an action that is arbitrary must necessarily involve negation of equality. Whenever, therefore, there is arbitrariness in state action, whether it be of the legislature or of the executive, Article 14 immediately springs into action and strikes down such state action. This is right from the time of Royappa and Maneka Gandhi. They had brought in, my lord, Article 14 to hit legislative action as well. 51. In Sharma Transport versus Government of AP, this court defined arbitrariness, observing that a party has to satisfy that the action was not reasonable and was manifestly arbitrary. The expression arbitrarily means, and this is important, my lord, especially in the context of my submission of the multiplier of 12 months. The expression arbitrarily means act done in an unreasonable manner or fixed or done capriciously or at pleasure without adequate determining principle, not founded in the nature of things, non-rational, not done or acting according to reason or judgment, depending on the will alone. Ichhe and no chinta. That's without arbitrariness, depending on the will alone. In Bombay Dyeing and Manufacturing Company Limited versus Bombay Environmental Action Group, this court held arbitrariness on the part of the legislature so as to make the legislation violative of Article 14 should ordinarily be manifest arbitrariness. In Bidhannagar, this court held that a law cannot be declared ultra vires on the ground of hardship, but can be done so on the ground of total unreasonableness. The legislation can be questioned as arbitrary and ultra vires under Article 14. However, to declare an act ultra vires under Article 14, the court must be satisfied in respect of substantive unreasonableness in the statute itself. Not all these lines, which seem to, especially the definition of arbitrarily, seems to bring about it a negation of will and a fascination for reasonableness when coupled with will. This answers, my lord, the primary focus of argument of the other side, which has always been that legislature is, after all, the will of the people. And therefore, when the legislature legislates, it's the will of the people which is there. And courts will have to take into account that will of the people to be sacrosanct. Courts are now saying that that will of the people, if it is unreasonable, if it is not done or acting according to reason or judgment, If it does not have adequate determining principle, then it can be arbitrary. And how, my lord, 126, my lord, is rocked by this, my lord has just seen. I will not repeat, my lord, at the risk of being reprimanded, but how it has been rocked. Kindly see the effect of this rocking. In unauthorized, in Article 1, Section 126, you are not calling me a thief. Because if it is a theft, then it's something which has to be determined before a special class of criminal courts that are brought into vogue. I am not suggesting here at the bar that 135 cannot be adverted to, or 126 and 135, there is a pick and choose. I am not on that at all. I am saying 126 has its field, 135 has its field. If the field does not go into 135, then there's no question of criminal liability. But on 126, what is the main defense of the electrical utility, which has found favor in the Gujarat judgment as well? The defense is, I, as the consumer who slapped with a 126 provisional assessment, have a remedy of giving a objection, have a remedy of full-blown hearing, have a remedy of assessment before the assessing officer, participating in the hearing, getting a final assessment order, and a remedy of appeal. All these put together means that it cannot be uncanalized after all. This now begs the question. Please take it from here. I have given it a lot of thought. Despite what has been stated, my lord, Mateen didn't go into this. My lord was not invited into this. I am sorry, my lord, at the bar that we could not assist your lordship in Mateen. We were going haywire in Mateen, as I have found. My lord has in fact saved us at the bar by trying to still string together an argument which connects it to virus again. But we were going haywire.
Let us not go into Mateen.
Now,
make your arguments.
Here, 126, my lord, 126, if you destroy the frustrum, then 126 is the harshest and the most draconian provision alive. The frustrum is important for its survival. And what is the frustrum? My right of availing all remedies under 126, because it's a complete code, a la Sitaram. If I have the right of availing every remedy to the hilt, then it has to be 127 as well. And that single 126.5 upsets a huge part of my right.
It does, Mr. Banerjee. You need not repeat that.
I'm sorry.
It does.
I'm sorry.
You have to put in the entire amount for getting a reconnection. You have to put in 50% for taking out an appeal.
Article 21.
Several other
Immediately, my lord, if your lordship puts in that switch, kindly put on that switch.
That is there. That is
21, 19(1)(g).
Yes.
Immediately comes in. It rushes in because
right there has to be a manifest arbitrariness or total unreasonableness.
Yes, total.
Why is it totally unreasonable?
You are submitting me to the judgment of a person X. And my lord, may I use the expression? Crucifying me with afflictions.
You are at present also you are submitting your client to a person's judgment.
On the basis of
an extreme. I mean, we cannot take it to an extreme. There has to be a person who is adjudicating.
The honorable judge who is sitting and hearing matters, my lord, under Article 226 is a distinguished, qualified legal person sitting and dabbling in legal principles.
That's also legal fiction, Mr. Banerjee.
It's no dabbling in legal fiction.
That's also legal fiction.
Dabbling in legal
principles. We are saying you are qualified and you go and judge. Now, how can we take that further? I mean, there has to be a person there who may or may not be legally equally qualified. I mean, with the others, may or may not be. So there has to be a person who adjudicates or assesses. So we cannot go into that, Mr. Banerjee, in a virus challenge.
Yes. When your lordship goes into the question of tribunals, my lord goes in. My lord kindly sees.
Yes.
Tribunals. This gentleman.
But this is a technical person.
No, he is a tribunal. My lord. Kindly, my lord, first, my lord, let us go step by step on this.
Some semblance of logic is there.
My lord,
State government is appointing. Whatever the other arguments, we are not going into that. Yes. But there is a semblance of a reason behind that.
No, state government appointing, it will be expected that he will not appoint a peon.
Not only that, the licensees, he may be a licensees person precisely because of the reason he has to be a technical person.
Yes.
So that's why, I mean, there has to be an assessing officer who does.
That's not your lordship's answer, my lord, to the point of bias, which I have not raised.
It's not merely bias, but the technical, there has to be a person who decides. Now you're going up to an extent, yes, twice you may say that's exorbitant. But you feel it's exorbitant, I feel it's exorbitant. Why do you say it's manifestly unreasonable?
Twice coupled with 12, doesn't it make it manifestly unreasonable? Does it cut my hands? When I come back, my lord, for a reconnection, doesn't it cut my hands?
That depends on the amount, Mr. Banerjee.
My lord, it depends on the working. What I'm saying is, my lord, what I'm saying is this, not kindly, my lord. Any technical calculation of this nature is objectively ascertainable. Why not ascertain the methods of
You
putting
say
in
there
the
ought to have
statute?
been more elements in this
Eh,
section.
No, complete. More or less complete.
Make it certain.
To make
There's
it
an uncertainty about
absolutely
it.
certain.
Very well, discretionary, uncertain. That I get your point.
Yes, absolutely certain.
What else?
Yes, tribunal point. The only last one, Lord, I'm so sorry. Tribunal point. I'm sorry, Lord, you have to glance up. And so
I have to
glance up, my lord, and see, my lord. So the length is getting.
I tried to make it very, very obvious. Yes, sir.
My lord. Now, my lord,
No, that's a good argument, Mr. Banerjee. I don't say it's a bad argument, but I mean, I've understood it at least prima facie, if not ex facie.
Understood it ex facie, I'm sure. Whether your lordship
What is the next point?
agrees with it prima facie is a
Don't make your debate here, Mr. Banerjee. This is a court. Yes.
My lord, may I, my lord, on this, my lord, after this, just go into another question.
Please do.
Whenever
Yes.
there is a tribunal appointed by a statute, that tribunal has to be such that the manning of the tribunal, the qualifications of the person or persons manning the tribunal,
those are not given here,
have to be specified in the statute. Please do not have any doubt that he is not a tribunal. Because then all those 52 Supreme Court, 58 Supreme Court, these I have not brought in. Irrespective, tribunal doesn't need to use the word tribunal, my lord. Tribunal is an authority empowered, armed, or tasked with the performance of a particular function, having a quasi-judicial element. His action can be completely administrative. It may have a quasi-judicial function. Here he has a quasi-judicial function. He's adjudicating rights. He's adjudicating how much I pay or how less I pay. He's adjudicating snapping of connections and restoration of connections, the conditions precedent or the like. A tribunal cannot be left as having mentioned to be appointed by the state government, full stop. There has to be a clear mention of the persons manning, their qualifications, their respective experiences, their tenure as such officer, give them tenure protection, give them control, appeal, and discipline rules and regulations have to be there. If these are not there, then this person is not appropriately protected to act as a tribunal. And then you give him a best judgment and a fiction of 12 years, the citizen goes for a toss. I mean, Lord, on this, there are judgments galore. In fact, number of tribunals have been, 2 or 3 have been struck down because of the fact that the appropriate, their constitution, etc., was not found to be appropriately grounded in the direct legislation. Subsequently, it was sought to be buttressed by subordinate legislation. Court said no, the imprint must be there in the direct legislation and he must have tenure protection. I'll tell you, Lordship. And assessing, I have been appearing in matters relating to the corporation for the last 24 years. Milord, ever since I was at the bar. Previously, I used to assist my father for another 5 years before that. It was like 29, 30 years now. I have never seen a hearing officer of the corporation, a hearing officer who has decided neutrally. He has always said, and this I'm not submitting in order to color your lordship's thoughts. This is a reality which all of us know. He has always said, if I bring down your proposed annual valuation to lesser than 20 or 25%, then I will not be there in the next cycle. This is why tenure protection is necessary. Tribunalization, not one of the biggest arms is tenure protection. Another biggest arm is control, appeal, and discipline rules. This gentleman acting as that assessing officer needs to have certain protections, needs to have a way to be dealt with if he has gone errant either way. Nothing of that sort is there. Very inconspicuously, and Sitaram didn't notice this because Sitaram was not told to go into the pitfalls of 126. Sitaram was told to declare what 126 was vis-a-vis 135. Here is a gentleman who has been very, very inconspicuously in a chapter 12, which starts with which is investigation and what is the name? Here suddenly investigation and enforcement. What does investigation and enforcement ordinarily suggest? Investigation into acts which are unauthorized use of electricity and the like. Now, enforcement and investigation is one thing, but this person is now actually a tribunal. Now, my lord, that would also, in my reciprocal submission, hit 126 badly because of the fact that this gentleman would be a gentleman who would not have the protection that is given or required to be given to every tribunal. These will be more or less my submissions. The other submissions are more or less, I found they overlap with the Gujarat ones. But my lord, at the risk of being seriously reprimanded, please give me a 10-minute time next day, any day, where I'll just come with the, I won't read out the judgments.
You have,
So
Mr.
I've shortened 11 or 12. What I want to do is, I want to make, my lord, a breakup where the corresponding paragraphs are before your lordships when I take your lordship. For your lordship, subsequent consideration in your lordship delivers judgment. But before that, the paragraphs just beside. So that when this 126 thing has hit me bad. Otherwise, I wouldn't have gone and argued a matter which has been decided by your lordship. Please, my lord, give me some time so that I can come.
File your
Expanded
judgments.
notes. No, judgments not only one. Give me a lot of.
File your expanded notes. Then.
Lord, please.
I'll take this as a just tentative note. Just.
Lord, I will expand those notes. But with that, please
I'm
give
taking
me.
it as a tentative note only for the purpose of because my own notes are here.
Yes.
That's
yes,
why.
Yes.
That is the only reason.
Yes.
I won't look into your whatever you have printed here. But whatever argued today, I have noted down. So those I'll look into. That's why I won't return this to you.
So what I have done is I've argued
This
what
on
I have
record?
written here.
Yes.
I've argued what I've written here. That is already.
Whatever submissions you have made, Mr. Banerjee, file your written notes of arguments on some other day.
I'll do that on that day, not a day prior there to on that day when I bring everything. Please hear me once, please.
On what? You have made your arguments.
Only on
I've
those.
given you 1 hour, Mr. Banerjee.
Yes, my lord, I am grateful, my lord.
What else?
I'm
Why?
grateful. Oh, just give me 10 minutes, my lord, to place those judgments before your lordship. There are
Do that today. Do that today.
There are certain limbs which are required to be coordinated and given. Otherwise, it will become a huge, humongous affair. Please, my lord. I ordinarily do not, my lord. I ordinarily do not, my lord. Sometimes I am guilty of dilation. Please.
When?
Tell me, my lord. It's completely whatever falls from your lordship, my lord. I
Can you do it tomorrow?
Friday. Would your lordship take it up on Monday? If it comes to your lordship. Monday is a new week, but we are more or less Monday, if your lordship comes to your lordship. I'll just come with everything prepared, and there your lordship can time me. Your lordship can time me, and then Lord impose costs on me if I exceed.
After that, he will argue also. So that has to be given. Your 10 minutes is not sufficient. We'll have to hear Mr.
Mr. Nayak will also have to be heard. I'll not finish in 10 minutes. 10-15 minutes.
At order record corner. Hard in part. On the prayer of learned counsel for the petitioner, the matter is adjourned for further hearing till May 15, 2023.
But instead of 15, 16.
No, 15. Come back on 15. I'll forget whatever I have heard. Come back on 15.
Lord, I will request my learned friend to give a copy.
What is no reference?
I'll come back in 10 minutes. In 5 minutes.
Obliged.
Not for this matter. For the
Obliged.
Being led by Mr. Shannan in this matter.
You are for the petitioner?
I'm for the Calcutta issue.
Oh.
Mala directed to file a report what action corporation has taken. Mala, in fact, the demolition case has been fixed for hearing on 25th. Mala, all steps have been taken which will appear for the report.
Can you please give a copy of
Mala,
this to them?
kindly, please.
You know, I have got a, what is that?
Your lordship directed me to prepare a list, so that
List of date. So far the petitioner is concerned and so far corporation is concerned.
Oh, this is a
Mala-
petitioner, sir.
Yes.
by last order, your lordship directed us to prepare it.
400 notice has been sought and demolition case has been fixed, my lord.
Can you please circulate copies of this to the other sides?
No, not yet.
Because if unless they get copies, they won't be able to address on this. So thank you for this. I mean, just please give copies to them. Mr. Shanal, I'll direct circulation of copies of this report. A report is filed by the Kolkata Municipal Corporation pursuant to previous direction of court. Full stop. Let copies of the same be circulated among learned counsel
Has
for
been
the
circulated. Already been circulated.
to all of them. Fair. Later copy na. The copies of the same are circulated here and now to learned counsel for the other appearing parties. First up, if you want me to hear it today, Mr. Shanal and Mr. Ghosh, I can take it up today also. Or if you want to go through this, I can take it up some other day. also. Tell me, should I hear it today?
No, your lordship should not.
I think they'd better go through this.
Yes.
So please come back on the next day. When should I keep it? Monday?
After vacation, Lord.
After vacation.
Because Lord, I will not be here next week. I have some difficulty.
Very good.
Well, hearing has been fixed. Nothing is left now.
Nothing has been left. So probably by then the hearing will also be over. If it is over, please ensure that a supplementary report is filed. I mean, I'm not directing that because that will be construed as a direction on you to complete the hearing. I don't want to do that. Do it, and if it is possible, just use another report. So, acha, on the prayer of learned counsel for the parties, comma, in order to enable learned counsel to address on the report, the matter is adjourned and shall next be listed in the monthly list of June 2023. Full stop. If you want to file objection to this report, because these are all facts, if you want to file objection, I'll give you liberty. In the meantime, please do that. So objections to the report, comma, if any, shall be filed.
Lord, that objection to that report
this.
filed earlier. No, this report will have to file.
Shall be filed on the next returnable date. If you file objections, please ensure that copy is given to your learned friend before that. Thank you. আরেকটা লাইন অ্যাড করে দাও a list of dates filed by the petitioners today be kept on record as well.
Item number 16. Item number 16.
Lordship, in item number 16, Ms. Choudhary Bhattacharya is appearing for the state respondent. She is on her legs before the courtroom number 18. I am
You are
for a
there.
third pass over.
You are Mr. Kapas.
No, Your Lordship. I am her private junior.
Oh.
I am not in the state panel, Your Lordship.
Sir, Bhumik is there? Yes, sir. What do you say? Mr. Bhumik and Mr. Gu are coming every day.
But the other side did not.
You are reading the matter.
Bhumik leading me.
What is the matter about?
Blood.
This is not medical council.
No. A student's life was gone. He was a scheduled tribe. He got a chance to get a scholarship from the central government after due selection.
Achha.
Then central government remand the matter to High Court, to the state government to confirm his status, the certificate and the income of the family. It was confirmed by due inquiry. Everything is in his favor. Even then, the fund was not released. That's why the petition in earlier occasion first
fund for what, Mr. Bhum?
The scholarship fund.
Scholarship.
That was not released. That's why he first appeared.
What is his subject?
Pilot training, commercial pilot training. Then he moved the first writ petition. A writ petition, when he moved, at that
during the pendency, the first time the government raised an objection that we have received a complaint against the writ petitioner that his certificate is not genuine. That's it. Then Justice Dipankar Datta, as his lordship then was, then Justice Datta referred the matter to the SDO concerned, who is the issuing authority, to make an inquiry and file a report. The SDO, instead of making an inquiry, asked for the certificate and cancel the SC certificate. Immediately, the Justice Datta as usual set aside that order, and the matter referred to the DM. DM, without due process of the law as statute also, now cancel the certificate. And that this is the second time I am approaching your lordship. This is the writ petition.
You are challenging that
Decision
cancellation.
of the-
Where is
Yeah.
that cancellation? Let us come to that. She'll come in the meantime. She's on legs in some other court. She'll come in
Number
there.
80.
Fate of a student, no, we cannot wait for long. Yes. Where is that impugned order?
Last
The schedule caste or tribe, Mr.
Still tribe. On the Beria group, it is a Mahato.
177.
Kindly come 177 page starts. It starts 79, 79.
The longish order.
Long order.
The finding was that you have failed to establish that your state of origin is West Bengal.
But I am a student of at that time of 22 years old.
Is the state of origin defined somewhere?
No. Not even the statute. SC/ST Act 1994.
You have a copy of that statute?
Yes.
Is argue on the relevant section? Chamber Junior saved. Yes.
Roots of record.
Please take your seat, Ms. Bhattacharya, so that you can't escape.
Yes.
Yes. Yes. What is the relevant provision?
Not for cancellation, section 9, if your lordships kindly come to the section.
Yes.
Section 9 of the Act itself. If the certificate issuing authority is satisfied that a certificate under this Act has been obtained by any persons by furnishing
Please
any
give the
false-
microphone. Yes. Yes, please continue.
uh,
Continue.
by furnishing any false information or by misrepresentation, depending any fact, or by suppressing any material information, or by producing any document which is an act of forgery, it may cancel, impound, or revoke such certificate in such manner as may be prescribed. Then 9(2). Notwithstanding anything contained in subsection 1, if the committee is satisfied, the screening committee that is introduced as per the decision of the Supreme Court in Madhuri Patil, that was introduced in the Act itself, and the power of the committee also enumerated in the Act itself. If the committee is satisfied that a certificate under this Act has been obtained by any persons by furnishing any false information, or by misrepresenting any fact, or by suppressing any material information, or by producing any document, is an act of forgery, it may issue a directions to the certificate issuing authority in such manner as may be prescribed to cancel, impound, or revoke such certificate, or on receipt of such direction, the certificate issuing authority shall by order and in writing cancel, impound.
So there are two modes. The certifying authority itself can, or by suggestion from a direction from a committee.
After introduction of the 9(2), the supremacy of the committee is established.
Very good.
But before that, going to that, I want to start in
Mr.
another.
Bhowik, one still remains. Two contains a non-obstante clause.
Yes.
Notwithstanding one, two may take effect. If a committee feels, it may direct. But
the
in spite
the
of that,
manner of the ultimate, this is also the decision of our apex court,
very
the division bench.
Very good.
The committee decision is the final.
Well, I'll look into that.
Before that, the whole case is made out on the basis of complaint. That here, I have lost the annex the complaint. Kindly see the complaint. There is no complaint against me. They have disclosed it at that after the showing only when they show cause me, issue the show cause letter. Then I got the copy of the complaint.
But the language is if the certifying issuing authority is satisfied that a certificate, complaint need not be an origin as per the statute.
No, if you
whatever mode it may gather that information and
but in the instant case, the action was taken on the basis of complaint. Show cause are issued. In the show cause, they have disclosed what is the allegation against me, what on the basis of complaint, then the complaint is the basis of the whole proceedings. So if the complaint goes, the entire edifice will fall. The kindly, I am pressing the what is the complaint. Kindly come page 90, Miller. Yes. In Bengali script. মহাশয় বিনীত নিবেদনে এই যে আমরা অবদলিত নিপীড়িত অবনমিত বঞ্চিত বেদিয়া মাহাতো সম্প্রদায়ের আবেদন যাহাতে আমরা এসটি হিসাবে সার্টিফিকেট পাই এবং এসটি হিসাবে সরকারি সুযোগ সুবিধা ও তার জন্য আবেদন। আমাদের প্রকৃত পরিচয় হলো পূর্ব সিংভূম, শিরিডি, ছোটনাগপুর সামথিং। If I place the entire, there's no allegation against the petitioner. No, nothing is mentioned against the petitioner. And it is made by a one Omesh Chandra Mahato, Samapati, Poschim, Dokhin Dinajpur, Bedia Kollan Committee. This is not a complaint against me.
so the Bedia community is wanting it a recognition.
Yeah, recognition so that they can get the certificate.
This is rather in your favor in a sense.
Yes, in a favor. They make it reparation. On that basis, they have initiated the complaint against me.
You are a signatory or an office bearer of this?
No.
What is the malafide? I mean, why was it? Why was this step taken?
So then, kindly, I am placing this some decision of this court in earlier writ petition. It will be very much clear. Justice.
Was there any reason for this malafide against you? Why were you picked up for this action?
We have approached this High Court that we got the selected. And my scholarship was sanctioned by the central government. And so it should be released in my favor. Central government referred the state government to verify the status and the income survey. It was by their committee. They have recognized me that yes, my certificate is genuine, everything. Even then I did not get the scholarship. That's why I approached this High Court. During the penance, and it will be clear from the earlier judgment, decision of this High Court that for the first time we have received a complaint. This is the
that may be a reason you approach the High Court.
Yes. Now, if the basis of the complaint is this, and on the entire proceeding is the complaint is this, there's no complaint against me. The how they proceed.
Any other point, Mr. Bhumik? Yes.
Yes.
The complaint has no basis. This is not a complaint at all.
At all against me.
Very good.
I have after show cause I have replied it.
And what is the show cause? Just show me the show cause.
Yes.
Give me the page numbers. I'll find out.
88. Page 88 is the show cause. very basis of the proceedings.
The entire thing was after the judgment of this court, the order of this court, direction.
Yes. 88.
Yes.
Whereas it appears that a complaint from one Umesh Chandra Mahato was received by the secretary, backward class welfare department, copy enclosed, and whereas on prima facie inquiry and findings being satisfied, it appears that the scheduled tribe certificate being number such and such of Kolani dated is liable to be cancelled, impounded, and revoked under section 1 of the section 3 West Bengal scheduled caste and scheduled tribes rules, for the reason the particulars of which are given below. The very basis is the complaint. Whereas 18 and 9 the grounds, lack of documents in support of your family residence in West Bengal prior to 1950, your predecessors stating their caste to be Hindu in the official instrument of land transfer. That
Complaint copy was also served on you. The next.
That is along with the complaint. That's the first time I got the Then I have.
It was annexed to this, enclosed with this.
Yes. For the first time. Then I give the 93. I have the reply. Each point was dealt with. Then there is a hearing in the,
did you take this point before the authority that this is no complaint at all?
Yes.
How was it dealt with? Yes. How was it dealt with?
They have not allowed me to depose on my behalf because I am the youngest in my family. My brother, I have also annexed a supplementary affidavit. That is a affidavit of my brother, cousin brother. He has deposed that he want to place that this is our case. He has not allowed. No, if you make any statement that it will be thrown out from this hearing. That was the attitude of the hearing officer. But that is the factual aspect. But I am question of law. Law says there's a rule how the hearing will be conducted and the equality. That is also not followed.
The rules.
Yes.
But rules say suo motu it can be done also. Not merely.
This is not a case of suo motu. I could have understood they have issued a suo motu case. This is not a suo motu case.
Right.
It is on the basis of complaint. Now, there's rule 3.
In the show cause the complaint is mentioned.
Now,
wherever it appears to a certificate issuing authority on complaints or suo motu that a person, whatever.
I could have, if it is a case of suo motu, then the case is otherwise. But this case is initiated entirely on the basis of complaint. And practically there is no complaint against me. Now, rule 3 says, if you proceed according to the basis of the complaint.
Affidavits were filed in this matter.
Yes.
Yes.
Then the complainant should be given a notice.
Yes.
A complainant should come and he should ventilate his grievance against me. Then I can give an answer. But in that is also mentioned in the rules. Rule 3 specifically mentioned that. Where it appears a certificate issuing authority on complaint by any person or suo motu that a person in whose paper the scheduled caste and scheduled tribe certificate has been issued does not belong to such caste and tribe. The certificate issuing authority shall hold a preliminary inquiry. That inquiry also not separate me.
It is the provision for serving a notice on the complainant, hearing the
yes. Where any rule 3
there is no provision for hearing the complaint.
Yes, but C and B.
B.
Yes.
Acha, yes. Holder of the certificate, they have to issue a notice. That is contemplated in 1, 2, and 3. But B, 4B says
a copy of a notice issued to the complainant, if any.
Yes.
And the holder of the certificate shall be affixed in the. This is the manner of regulation, rules.
Oh yes, 4A also says that there has to be a notice to the complaint.
On expiry of the period referred in subsection rule 1, certificate issuing authority shall fix a date for hearing of the case by notice to the complainant.
Right, right.
And all the holder of the, and this is the usual
So
procedure.
on that ground itself, it should go, you say.
Yes. But,
Any other ground, Mr.?
yes, other point. And now,
What about this state of origin or is there a valid ground?
I must praise the affidavit opposition. They have used ultimately, it was a case of 2016. Now, in 2023, state government has used affidavit in opposition. Now, I reply to. I'm citing the first 1 and 2 paragraph in the special case. I, Hirok Mandal, son of Bimal Jatanda Mandal, aged about 50 years by occupation service, working as subdivisional officer, SDO, having his office something and do hereby solemnly affirm and say follows that I am respondent number 3, but in the my writ petition, respondent number 3 is some other person, commissioner. He's not a respondent number 3. So he's affidavit opposition cannot stand on behalf of respondent 3. And second paragraph, a copy of the writ petition was affirmed by one Sundeep Kumar Singh Roy on 15 June 2022. My case of 2016, I am Utpal Mahato. This copy was served upon the state government, and they dealt with my writ petition in such fashion.
But the facts are relevant, what have been stated here.
And I have
My lord, in this regard, my lord, I missed it, but my lord, otherwise also, my lord, he's a very junior member, my lord. He committed a mistake, my lord. Those are the annexures. And my lord, surprisingly, my lord, what he could not understand the importance, as my lord, which was the draft was approved by the DM, and my lord, which were the annexures, my lord, as the officer did not come with those annexures and requested him to delete those and make the, and my lord, he did so, my lord. That is his mistake, my lord, I admit. But my lord, this I was also missed to observe. I only annexures that I observed.
The annexures, you are relying on the annexures.
My lord, those annexures which
Different.
ought to have been relied, and draft which was approved by DM, my lord, there those annexures were mentioned. And my lord, under the instruction, my lord, he committed the mistake, my lord. On behalf of him, my lord, I beg pardon with folded hand, my lord. Kindly grant me leave, my lord, to use the fresh one, my lord. Because this is, my lord, the more mistake he committed.
But
That
Ms.
is Shondeep
Bhattacharya, the
Singh Gorai.
difficulty is this person is litigating from 2016.
My lord, I am withdrawing it. All the documents is with in his writ petition. Only I am coming with the compilation. My lord, I am withdrawing my affidavit in opposition.
After reply.
Because, but my lord, the junior member will
After
be
7
problem,
years,
my lord.
after 7 years, last chance, very last chance, special last chance, they have treated me in like this. My whole life as a stake. I got a chance
My
from
lord,
a
kindly save a junior member, my lord, because he has committed a very, very
So,
problem.
comic save him.
This is not my case. Kindly consider the poor boy.
Yes, yes. Tomorrow I
Kindly
am working, my lord.
kindly consider the poor boy.
Tomorrow you'll do it.
Yes, yes, my
Oh,
lord.
very-
With all documents and compilation, I am
No,
coming.
tomorrow give copies to them.
Yes, yes, my lord. All
Those with the other documents.
Yes.
Give copies to them tomorrow.
Yes.
And I'll take it up on Monday.
Monday. Yes, my lord.
Very well.
And my lord, I am withdrawing, my lord, that let it be
I'll say you're
recorded.
not pressing this and the reply also goes then.
Yes, yes. My lord, I am not pressing that.
But I'll have to give some reason. After so long, can you do it?
That's
After supplemented affidavit by you.
yes, yes.
Annexing some documents.
Yes.
I got the scholarship from central government. They spoiled my life.
learned counsel for the state at the outset submits that due to certain communication gaps, comma, entirely wrong set of annexures have been enclosed along with the affidavit in opposition. Full stop. Apart from that, there are certain other glaring technical mistakes in the opposition. Full stop. As such, comma, the state does not want to rely on the opposition. Full stop. It is seen from the records that after several years, comma, the opposition was filed.
But
And
my
the
lord, may I
reply-
pray one indulgence?
I'll have
my
to
lord?
record this.
Yes, my lord, but my lord, kindly, because I will be also in trouble because as the draft has been approved by DM, my lord.
When did they approve?
My lord, that before filing this, and that draft is, my lord, he has changed on his own without asking me. My lord,
Don't
kindly allow me
castigate him,
one
don't
day more, my lord, I will make it affirm further. One day more, my lord, I
No,
will.
no,
make
you'll
it.
give only the documents you said.
No, my lord, as the draft has been approved by DM, my lord, that is, I am praying, I am.
DM is
beseeching.
not sacrosanct in my court.
Yes, my lord.
DM is not sacrosanct in my
No,
court.
we will be in difficulty. Because my lord, order was there and we have sent the mail and my lord, mail was approved by DM and we will be answerable why the affidavit was wrongly written and my lord.
কি বললাম despite? Last sentence. এটা কেটে দিন এই সেন্টেন্সে লাস্ট সেন্টেন্সে কেটে দিন আগে পর্যন্ত যা বলেছি তা থাকবে
Reply করতে সেমই থাকবে আমি অন্য
Full
কিছু
stop.
রিলাই করব না
It is unfortunate that after so long, comma, such point is being taken, comma, particularly after the reply has been filed. Full stop. However, comma, as a last chance to the state, comma, on the prayer of learned counsel for the state is the respondents are permitted to file a further affidavit in opposition by May 15, 2023. Full stop. Reply, if any, shall be filed. Your documents will be different then.
No, my lord, no documents will be different. All are my lord, the notification and everything. I
So
will-
file a reply in 3 days. I'll take it up
Yes,
with the
yes,
vacation.
yes, my lord, before this vacation.
Reply, if any, shall be filed by
Monday. My lord, the opposition by Monday, I will. Yes.
reply, if any, shall be filed by May 18, 2023, when the matter shall next be listed for hearing. If I add one more sentence, Mr. Bhomik, then some people will be in difficulty unnecessarily, members of the party.
Yes, my lord, and because he is with this kind of face, he is.
আপনি মাইকে বলে আপনার গলাতে।
Item number 17.
Yes, he is appealing for the petitioner. You are
Yes,
appealing?
well, I appear.
Yes.
Well, there is a short point involved. My lord,
But I am for the respondent.
well, a complaint was lodged by the authority under section 135. And my subsequently, well, one provisional bill was raised. Well, I got bail from the Honorable High Court and deposited, my lord, out of 8 lakhs, 4 lakhs I deposited. And বলে দিচ্ছি short টা, madam. Thereafter, my lord, criminal proceedings started under section 135 and I have been exonerated from the charges. And thereafter, I wrote a letter to the authority, kindly, I have been exonerated from the charges by the learned criminal court. Kindly refund my money deposited in terms of the court's order. Since, my lord, no final bill was raised, provisional bill goes, my lord judgment, opposition Mujumdar held, if the authority did not file final assessment within 30 days.
Appreciated.
That is my case. And my landlord friend, my lord.
Well, here case is
Definitely.
totally different. My landlord is saying there is no provisional assessment, but fact remains provisional assessment has been
No,
challenged.
he says there is no final assessment.
Final assessment. Why not final assessment has not yet been done? Because he has challenged the provisional assessment. That provisional assessment was, court has already passed an interim order directing us to do something. That matter was came before your lordships on 27th March. Well, unfortunately, due to loss of my father, I was not there on that point of time. My landlord friends will not, I have seen this order that he has already says that assessment amount has already been paid. So therefore, there is nothing remained to the writ petition that was disposed of. So, my lord, there is no scope for final assessment because of
there was
pendency
no
of.
stay. There is no stay.
No, Justice Pranab Chattopadhyay's
No,
order
stay
was
ছিল
there. Interim order was there.
For
As
my-
his lordship then was, but Justice Pranab. Anyway, your lordships kindly hear out the matter any day or
Which day? Tell me
And
the
my lord, your lordship,
That chapter.
your lordship has already passed, my
Before-
lord, so
before
many
vacation,
matters, so
before
many
vacation.
judgment by same point.
Only I
Already.
So when should I keep it? Tell me, Mr. Kole.
I shall only rely to opposition judgment and
There are other
no
judgments also.
My lord had already passed 3-4 judgments.
I am in the habit of passing contradictory orders.
And
So
my
don't
lord-
rely on my judgments ever.
And my lord,
So find out some judgment from the
Yeah.
Supreme Court.
and one judgment your lordship has already passed directing us to refund. My lord, I have
Depends on
heard,
the facts of the case, Mr. Kole. We'll have to look into the
Yes,
facts.
yes.
because I have heard, my lord, that they have, the WBSCT.
Same formula may not apply everywhere.
Yes.
Anyway, I'm keeping it tomorrow then. Tomorrow
Next
is a good
Thursday,
day.
next Thursday. my lord.
Thursday.
No, because I am searching from another judgment from the, apart from your lordships.
You'll find it by Thursday.
16 or 17.
A common date, I'll keep it on that.
16.
Common date.
16.
Anyway, 16 or 17, since my learned friend is my lord,
On the prayer of Learned Council. for the-
17, your lordships kindly. Yes.
On the prayer of Learned Council for the WBSCTCL.
My lord.
On the prayer of Learned Council for the WBSCTCL, the matter is adjourned till.
My lord, my learned friends also. my lord.
Both. Otherwise, he will be able
Prayer
to
of Learned Council for the
fee,
parties,
my
the matter is adjourned till May 17, 2023.
He will be in difficulty, my lord.
No, no, since it's a prayer book.
Item number 18.
বাবু এটা না আগেরটাই ঢুকে যাচ্ছে যেটা ওই সোমবার রিপ্লাই চাইতে ঠিক এর আগের ম্যাটার ঠিক আগের ফেলাতে যেটা শৈবালেন্দু ভূমিকা দিয়েছিল বিপ্লব ছিল Yes. ওই যেটা উৎপল মাহাতো ভার্সেস সামথিং হ্যাঁ Yes, Mr. Ghosh, what is it?
My lord, his application for contempt, affidavit, my lord, today was the last chance. So I have got, it's out of time, I have got it prepared. my lord. Rest I leave it to you, lord.
I was offered a copy, but my lord, since my lord, this is
We
my
should
lord, a
have been
contempt
taken.
matter
We can-
between the court and the contempt, my lord, I without leave
I'll
of
accept
your
the. So when do you like to file? Do you want
the
to use it?
affidavit discloses my lord, commission of an act of contempt. My lord, on the face of it. My lord, which was my lord, fairly admitted by my learned friend, my lord, of the last occasion. My lord, this recorded, my lord, in my lord's previous orders. Kindly, my lord, have a look at page 108 of my contempt application. It will not take, my lord, more than 5 minutes of my lord's time. Page 108 is the order, my lord, of which, my lord, I am alleging, my lord, contempt. এদিকে চলুন।
Justice Shamadda.
Sorry. Okay. My lord, this was, my lord, the order, my lord, passed. My lord, there was, my lord, basically a rival claim with regard to, my lord, the retirement, my lord, the terminal benefits of the employee, my lord, who passed away. My lord, two ladies were there, my lord, who were had competing claims, and my lord, were claiming themselves to be the wives. My lord, an
Yeah,
order
but
was
the
passed on,
authority
my lord,
yesterday
13th of July. My lord, directing the, my lord, employer not to disburse any amount, my lord, without, my lord, the right being first adjudicated upon, my lord, by a civil court. My lord, after this order being passed, my lord, the controlling authority, my lord, has passed an order directing, my lord, controlling authority under the Payment of Gratuity Act. My lord, has passed an order, my lord, with a direction, my lord, for release of, my lord, gratuity to, my lord, my rival claimant. My lord, the controlling authority was shown, my lord, the order, and the controlling authority has said that, my lord, he is the civil court. He has the right, my lord, to decide who is the wife.
I have nothing to do.
No, my lord.
I am, my lord, now caught in the
My
crossfire.
senior friend says that, my lord, he
That
deemed
officer
it-
is still there.
I'm sorry, my lord.
The officer is still there in office.
This is my appeal. 225.
The confirming authority or controlling authority, whatever.
That I
To,
don't know.
to controlling the expression controlling too literally, probably, Mr. Ghosh.
And my lord, my learned senior friends, clients, my lord, deemed it proper, my lord, to abide by the directions of the controlling authority.
Already released.
Yes, instead of abiding, my lord, the directions of this order. You know, their lives, my lord, his act of contempt.
Palpable contempt.
My lord, there's an order, there's an appellate authority order. I preferred an appeal, my lord, I lost the appeal.
Right.
So, my lord,
But still,
on
this
this
order
ground,
was
and kindly
staring at
take
his
the
face.
grounds, kindly take the grounds, my lord, my affidavit in opposition, page 34. Page 34. And also, my lord, kindly take page 36. My lord, kindly take the grounds. I, my lord,
Preferred an appeal.
I preferred an appeal.
You are the controlling authority.
No, I am for the Eastern Coalfields. my lord.
Employer.
I am the employer,
Oh, right.
Eastern Coalfields. My lord, I am caught in the crossfire, my lord. My lord, I went and preferred an appeal. My grounds are at page 34. For that, the controlling authority ordered directing the company to make payment of rupees such and such to Mrs. Poonam Rai by holding her to be
No
legally
rule was
liable.
issued. No rule was issued at any point. I'll issue a rule. Controlling authority has been served. Was there any service? I'll direct you to serve on the controlling authority.
Milord, kindly allow.
B Millard, he is legally.
You are not at fault. No, you're right.
Milord, possibly, Milord, they are also at fault.
Why do you
Because,
say
Milord,
that?
they
How
were-
can it be?
Milord, two orders were pitted against each other. Milord, one order passed by this honorable court, one order, Milord, passed by the appellate authority under the Payment of Gratuity Act. Milord, he had an option, Milord, to follow the directions of this honorable court, or Milord, to follow, Milord, the contradictory.
If there is a scope of going two ways, Mr. Banerjee probably.
Milord, there was no
may not
way,
be.
Milord, of
Willful default, Millard. Willful deliberate.
what can be, Milord, more willful than this?
Milord,
Milord, I was
deliberate,
asking
Milord.
to myself.
Millard, I preferred an appeal. I took all these grounds.
Milord, the
I have been
employer
rejected.
is a public
What is the
employer.
occasion? You were directed to serve copies on them previously?
Yes, Milord, there was a direction, Milord, before.
Service on the contemner was affected.
Yes.
The other contemner?
Yes. Milord, affidavit of service to that effect is already, Milord, submitted.
And I
And
also,
Milord, by Milord offering these explanations, possibly they cannot pass themselves.
Millard, I also, Millard, wrote a letter at page 36, 11th of January 2016.
Why did you disburse in the first place? As
Millard,
per the order of the controlling authority.
Millard, I preferred an appeal. I lost in the first forum. I preferred an appeal. Appeal court, Millard, all these grounds taken. I lost that also.
Milord, this,
After that you disbursed.
As but that I disbursed. Not that I, Millard, sat tight with the order. I went to
Milord,
the
all
appellate
these
authority.
proceedings could not have been, Milord, even initiated, Milord, at the instance of the employer. Milord, section 7.
Was there any direction in the High Court's order to who will initiate the suit?
No,
It has to be between the parties.
No, that was
Interstate
between the
parties.
parties.
Why didn't you file a civil suit?
Suit file,
You should have filed a civil suit.
suit file হয়েছে তাও জানি না।
If you keep tight over the matter, you will never get the,
No, Milord, there is a proceeding pending, which
I
is,
don't
Milord, a civil proceeding, Milord, which is
proceeding. What do you mean by proceeding?
Milord,
Civil suit.
pertains to, no. Milord, pertains to, Milord, issuance of a grant of succession.
If you did
certificate.
not file a civil suit, Mr. Banerjee, how does it lie in your mouth to say these things?
But
They
Milord,
preferred an appeal rather against the controlling authority order.
after, Milord, initiating, after setting the ball in motion. Milord, section 7 says, Milord, if the employer wants to disburse, the employer has to take out an application before the controlling authority. Milord, after this order passed by this honorable court, there is no occasion for them, Milord, to approach the controlling authority.
Milord,
At the first place.
I am holding someone's money. For that admission, Millard,
just
he is
show them,
Millard,
Millard,
he
the
is Millard.
The context of your going to the controlling authority, Mr. Ghosh?
Yes.
You approach the controlling authority after this order.
Yes.
I'll just,
Why?
Just Lordship, please.
Mhm.
Form 7. Kindly take Millard, page 27. Justice Shaw. দাঁড়াও বাবা, দাঁড়াও, এক মিনিট দাঁড়াও।
May I, Milord, be favored with a copy with Milord's kind leave, Milord, of the affidavit?
Oh, you have not got a copy of
Milord,
that?
they
I
offered.
I offer.
They offered.
Achha,
Milord, since
I
this is
offered,
between your lordship and the contemner, Milord,
I do not know,
Did not
Millard.
Don't want to use a reply, just indicate to me tomorrow, I'll keep it tomorrow.
Srimati Shopna Basu Rai,
It's
another,
on Monday.
there are two claimants.
Yes.
So Shopna Basu Rai filed an application under section 7 of the Payment of Gratuity Act before the
Before the
authority.
employer, Milord, employer takes it,
Baba,
Milord, to
dale
the
baba.
competent
No,
authority.
we'll look into that. Mr. Banerjee, without going through his affidavit, don't make comments. I mean, let us see what steps you have taken.
Milord, I can see, Milord, it from here, Milord, I will come back.
আমার কাছে আছে তারপরে ফাইন্ডিং
This
দিয়ে
is so apparent. Milord, I'll come back. On
An affidavit in opposition filed on behalf of contemner number 4 today
Suit
be
file
kept on
করেছে?
record. Full stop. The delay in filing the same is condoned. Full stop. Learned counsel. A copy of the same is handed over to the learned advocate appearing for the petitioner. Full stop. In order to enable the petitioner to take instructions on the averments made therein, comma, the matter is adjourned till May 15, 2023. Full stop. Yes, come back on May 15th. We'll see.
সোমবার তো
Grateful.
মে আই গিভ ইউ আ
Monday.
কপি
Please give a copy.
তাহলে মঙ্গলবার
সোমবার
আমি আছি
Grateful.
1 to 3 in any event, probably I may issue rule subject to, because if I have to issue a rule against them, I have to issue a composite. I mean, together.
I
The
follow.
rules will be together.
I
Otherwise, I'll absolve them and issue the rule against
But I
them.
follow. Milord, I try to rope them
and
in
Millard
also.
number 5 Millard এসছে, একটু আচ্ছা এসছে।
You don't want to use an affidavit
Affidavit use করতে চাও?
against the contempt. Very well.
Because my lord, Assistant Labor Commissioner who has passed the order, my lord, in consonant compliance with the order passed by this.
We'll look into it.
And my lord, I don't find any averment on the contempt. The suit has been filed or a suit is pending.
No, I did not see that.
So it has not been, then my lord, contempt will not lie. That will be my argument.
Let's come back.
Item number 20 and 21.
Lordship, this is my application for contempt. This is against that rent controller and the additional rent controller Shalda. Lordships, an affidavit has been filed today before your lordship. Well, kindly take that affidavit.
Well, this is the affidavit. These are affidavit. My lord, may I place the whole issue before how it has been done? Before that, my lord, I would draw your lordship's attention to.
Lordship will kindly
your
allow me to
lordship's
place,
order.
then my
It is
lordship
between the
can
contempt.
address.
No, let the contempt start first. Yes.
Very well.
I draw your lordship's kind
Do
attention.
you want to use a reply against this?
Lordship, it's not required because they have admitted to the contempt in the affidavit.
Certainly.
That's what I wanted
Hear
to.
hear the petitioner first. Let us hear the contempt application. They're not using a reply here on the contempt application.
Just place
Let
it.
us, no, take it. Yes.
Your lordship will kindly take the affidavit affirmed by Shri Partho Acharya. Lordship will kindly take internal page 4 of such affidavit.
Yes.
Lordship will come to paragraph Roman 4. The main grievances as body raised in the application, which is the names of all the joint tenants could not be given in the challan issued. The names of the landlord could not be inserted in the challan, and the deposit could not be made online physical at the office of the additional rent control Alipur and additional rent control Srila. Admittedly, these were the issues. Now, this is how my learned friends guys deal with that. So far as the first and second issues are concerned, the statutory challan clearly shows the names of all the landlords and tenants, hence the same grievances dispersed into oblivion, and they disclose photocopies of relevant challans. Kindly come to Annexure A, which is at page 30. Lordship will find this is the first challan. Your lordship will find the last entry is rent for the month. Rent for the month April 2018. And lordship will kindly take the date of initiation of this. Lordship will find on the second line 31st January 2023. Lordship, a grips query is taken out in 2023 for payment of rent in April 2018, which is categorically contrary to statute. Your lordship, there are 3 sections I will place. One is section 21 of the West Bengal.
What is this GRN date? Oh, period from.
Yes, my lord. Lordship, it is being issued today for payment of rent for the period April 2018. Lordship, this is the grips challan which is.
So your allegation in the contempt is that the challan contains no provision for these, the name of joint tenants and all this.
Lordship, what I'm trying to place today is these challans have been manufactured because this could not have been issued. This is contrary to statute. Lordship will find on 31st January 2023, a challan has been made for payment of rent for the month of April 2018. Lordship, this is contrary to statute. It's contrary to section 21 of the West Bengal Premises Tenancy Act. It's contrary to rule 9 of the West Bengal Premises Tenancy Rules and rule 4. They could not have. Your lordship will remember this is also contrary to the report which they have filed and contrary to this affidavit, because they could not. General procedure is the last month's rent receipt has to be shown, then only the rent receipts can be issued. This has been manufactured only to show that rent is being paid and nothing else. This is contrary to law. But lordship, I will place section 21 before that.
Mr. Court, do you say that,
Lordship,
even today you are sticking to your allegation in the contempt application that it cannot be done even today?
Even today it cannot be done. Right. Lordship, and what my learned friend is trying to show as documents to show that it is being done, these are being manufactured. I will show your lordship first why. It is for April 2018. Lordship, it is contrary to section 21 and rule 9 of the West Bengal Premises Tenancy Rules. It could not have been generated. Lordship, also very interestingly, kindly see the name of the depositor. It is Jibon Bormon. Now kindly take the contempt application. This was the pro forma which was disclosed with the report, which was disclosed at the time of disposing the writ application. Your lordship will find that at page 76. of the contempt application. And it's for the same month, April 2018. Has your lordship got page 76?
Yes.
Your lordship will kindly take, this was on 12th January 2023, Jibon Bormon, for the month of April 2018. Same document. Lordship, it is also contrary to the report which has been filed. Your lordship will kindly take the contempt application, page 67. This is a part of the report filed by the rent controller. Lordship will find page 67.
Right.
In second system, tenants intending to deposit rent in physical online mode will visit the department counter along with the previous month's paid challan. Kindly ask the rent controller to disclose this, whether this has been followed. If they are not, if this has not been followed, they are in contempt.
One is violated. Section 21 is also violated.
Section 21 is violated. Rule 9.4 is violated.
Rule 9.4 comes thereafter, yes.
Lordship, so this is clearly in violation. Your lordship will kindly see, not only this, they have gone into manufacturing further documents. This is for the month of April 2018. Your lordship will kindly turn over to page 31. They show payment also being made, which is clearly in violation of the rules. This is of page 31 of the affidavit, my lord. They show payment is being made. Your lordship will find.
What was the date of filing of the contempt application?
Lordship, this
Before
is.
this? Before 31st October?
No, my lord. The contempt was filed in March, my lord.
March this year?
March this year. But all this has been made after the notice for contempt has been given. Lordship, the notice for contempt is on 19th February. All these documents have been made thereafter. Your lordship will find the notice at page 85. Lordship, I'm sorry, it's on 19th January that the notice of contempt was given, which is at page 85. Post this, all these documents are manufactured.
Yes. Anything else?
Your lordship will find in page 33, June 2018. Again, the same person. The affidavit is allowed. Your lordship. Lordship will find at page 33, allowed payment for June 2018. The earlier one was April 2018. Again, for June 2018, another query has been raised and payment has been allowed. Your lordship will find the payment has been made on 30th January 2023, I believe. That's the date right at the bottom. This has also been disclosed. Your lordship will find right at the bottom, GRN date, 30th January. Period from 30th January, period to 30th January. Lordship, Bank Gateway, State Bank of India, counter payment. It shows counter payment has been made. Your Lordship, there is an even more interesting aspect to this, because they on affidavit admit that they cannot condone this delay. Lordship will kindly take page 7 of that affidavit, paragraph D. Lordship, that's so far the statutory period of 15 days are concerned. Lordship will find this statutory period is under the rules, Rule 4. Under the West Bengal Constituency Act 1997 and Rules 1999, alleged default in not completing the procedure, the concerned rent control officers have already approached the concerned department for taking necessary decision over the issue. That such statutory time limit of 15 days or any relaxation thereto is subject matter of the legislature, and unless the appropriate authority suitably amends or takes any decisions, the rent control officers have no jurisdiction, authority, and power to deal with the same, for which no alleged contempt lies against the rent controller. So admittedly, they are not entitled to legally deal with
Mr.
this.
Kaur, is it possible for them to argue that this is an automated system? I mean, if somebody puts in by way of this grips challan and whatever, no human agency is involved, so it can automatically. But then they have to have some safeguard in the software.
Lordship, this is exactly where I have caught them, because if they say it was an online process,
right,
they could have gotten through this. But all these, they say, are in the physical format. They say that this is the physical format which is being used. So people have approached the rent control office with the last receipt. Based on that, this has been come, which is what they say. This is not in the online format. This is in the physical format. They say that this has happened. So they are not entitled to take this defense at all. Lordship, it's very unfortunate, but I will also show your Lordship a few more documents which has been manufactured by the Office of the Rent Control. Lordship will kindly come back to page 34.
What is the qualification of the rent controller?
Lordship, I believe it's a WBCS.
Page 34. Page 34. WBCC.
Execute.
Yes. Yes, page 34.
Your Lordship will kindly find this is the other rent receipts which have been disclosed on the physical mode. This has been paid. Your Lordship will find Syntho Coats laminates. Your Lordship will find that this payment is for December 2022. And the gateway, the payment initial date is on 16th March 2023. Lordship, going back to paragraph 7, page 7, paragraph D of this affidavit, they could not have done this, but they have allowed. Lordship will find something even more interesting. This is contrary to page 7, paragraph D of their own affidavit. They could not have granted this delay. Lordship will find this is for December 2022. Your Lordship will find that the payment, it's written in handwritten, on 17th March 2023. The payment apparently has been made at page 34. Your Lordship will find right at the top, 17th March 2023, the date is given when the payment has allegedly been made. So they are again doing something which they are legally not entitled to. Kindly turn over the page. Your Lordship will find for the same person, November 2022. Payment has been made on 13th March 2023, right at the bottom. So in the same month, 3 payments for 3 different months is being allowed to be done. Page 35 is for November 2022, payment made on 13th March 2023. Page 34 for December 2022, payment is made on 17th March 2023. Your Lordship will turn over to page 36 for the rent for the month of January 2023 is made on 20th March 2023. So the months of November 2022, December 2022, January 2023, all 3 months paid over a period of a week, 13th March, 17th March, and 20th March. Lordship, the same thing again at page 37, November 2022, allowed to be made payment in April 2023, contrary to their own affidavit. Lordship, my submission would be on the face of it, it's admitted, and it's also admitted that No deposits are being allowed in Shialda and Alipur. I will just place that portion of the affidavit. Your Lordship will find that at page 5. Lordship, it's the top paragraph. Lordship, so far the third issue is concerned due to logistic reasons and to facilitate the implementation of the integrated online system. Temporarily, the functions of at Alipur and Shialda is being conducted through the main rent control office at Kolkata, situated at Kiran Shankar Rai Road. And shortly after the whole system is updated and implemented, it is expected that again from the said locations, the process can be operated. It's admitted that they have not been able to do the online process or the physical process. Online process can be done from anywhere. The physical process is not being done. Your Lordship, coming to the report which had been submitted, based on which your
What was the
Lordship's-
third issue? Just let me check up first.
Lordship, the-
Deposits could not be made online or physically at the office of.
Lordship.
Very good. Yes.
Lordship, the issues are at page 4, paragraph 4 of that.
You place those, yes.
These were the issues that they were taking care of. Your Lordship will find the impugned order, your Lordship's order, which is at page 62. I'm sorry, it starts at page 61. The operative portion is at page 62. Your Lordship will take the third paragraph. It transpires from the report filed today and its annexures that the respondents have duly taken care of all the issues raised by the tenants in online deposit of rent before the rent controller. As such, no further direction need be given, nothing. Noting the court's appreciation for learned counsel appearing for the state for exercising their verdict, it is expected that henceforth the new modalities incorporated in the concerned web portal for online deposit as well as parallel physical deposits made in the prescribed manner will be adhered to in respect of deposits made before the rent controller. Lordship, this is one of the defenses that is being sought to be taken by my learned friend, that all these issues came subsequently. It is not. The main issues which were raised in the writ petition, which were sought to be dealt with in this writ petition, those are the main issues which has not
So
been
at
dealt
that
with.
point of time also, this was not the correct picture. So this is a fresh contempt application.
Lordship, this is the first contempt application. This is the earlier one
This
was.
order was passed on which?
Lordship, this order was passed in January. 13th
On a
January.
previous contempt application.
No, my lord, this is the writ petition which was disposed
Oh, this
of.
was the writ petition itself, right?
Yes, the writ petition disposed by this order on the basis of a report filed by my learned friend's client. Lordship, the relevant portion of the report is at page 67 of the contempt petition. Lordship, it's internal page 4. In second system, tenants intending to deposit rent in physical offline mode will visit the department counter along with the previous month's paid challan with bank staff. After showing the paid challan in the counter, the tenant will receive both the rent control from 3 Annexure 1 under 9(4) of the West Bengal Premises Tenancy Act 1997 and grips challan etc. to deposit the rent for the current month in any breach of State Bank of India. Where
So this is the order under contempt, you say?
Lordship, this was the report on basis of which the order was passed.
Yes.
Because it was assumed that all the issues were sorted out.
That is itself a contempt because that report was. Let me hear. Yes. What do you say?
Firstly, my lord, the allegations raised that manufacturing
Come
and
to the
all.
point.
Yes, I'm coming, my lord. I'm coming to that because serious allegations have been raised against the authority.
Deal with them first.
My lord,
The other things will.
may I just want, because I have taken the point of maintainability. Before that, I
What
assure.
maintainability? You can show me to issue rule of
No,
contempt.
no, I am just.
What maintainability?
My lord, I assure your lordship that I will satisfy the points raised by my learned friend. There is no manufacturing or nothing because it is not possible because there is one QR code. With a QR code, there cannot be any document can be manufactured. That is the law. This is the technology which we are living in today's world. We are not living in the previous method of physical submission and all. Now, my lord, kindly take the order under which this contempt application has been lodged. My lord, 13 January 2023. My lord, kindly take this order. My lord, from the second paragraph itself, I'm not troubling your lordship much. The issues which were raised. First issue is regarding the bank. We have integrated with the bank. Second is that the upon necessary correction incorporating provisions of including names of one more landlords and one more.
Which page?
Page 61 of the application.
Hmm.
First issue is the integration with the bank. The second paragraph, I've divided in these 4 parts. Second is that necessary corrections incorporating provisions to include the names of one or more landlords and one or more tenants have already been incorporated. This is the part 2.
Page 61.
61 of the contempt application. Your lordship's order. 13th of January.
Yes.
Yes. My lord, kindly take the second.
Manager of the state, written to the manager of the state bank, yes.
Because we have integrated with the bank, because it is to be deposited with the bank through the grips challan, it is done. Second issue is this, the mentioning of the names of the landlords and the tenants. That we have done, that I'm going to show. Thirdly, the second paragraph of page 62, it is also contained that on the same web page, the tenant can also obtain and download relevant details. We have given all the details that I will show. Next, it transpires from the report filed today and its annexures that the respondents have duly taken care of all the issues raised by the tenants in online deposit of rent before the rent controller. So all the issues raised by the tenants in online deposit of rent. Now next, my lord, kindly skip over to the next paragraph. It says, it is expected that henceforth the new modalities incorporated in the concerned web portal for online deposit as well as parallel physical deposits made in the prescribed manner will be adhered to in the respect of the deposits made before the rent controller. So your lordship had acknowledged the new modalities and physical deposit through the prescribed manner. Kindly appreciates. Now, this is the prescribed manner. Now, what was the previous situation? The persons concerned could have gone to the office physically with this challenge old method. They could have submitted with the endorsement. They could have come back. Now, these new modalities have got the acknowledgement of this honorable court as well as the all over India, the digitalization is going on. So we have adopted this for transparency and fair rent collection and to lessen the hassle of the persons. Now, this prescribed manner, your lordship has categorically mentioned the prescribed manner. Now, what is pinching the applicant is that they have to give the benefit of that old process which they have been following. Now, what is the new modalities and prescribed manner? There are 2 ways. First, that is absolute online, sitting inside the room with a phone, it can be paid. Secondly, another prescribed is that the physical manner, the person needs to go to the office, show the last challan or the first challan, and they get an endorsement, they go to the bank and bank puts its endorsement. So we have not demolished or changed the whole physical challan system. It is there, but through the prescribed manner, which is not being digested by the applicants. There are other reasons, because, my lord, there are 55,000 tenants and more. Only one person has come up before this honorable court because only she is having problem. All other persons, those who are benefited with the system, they are not raising any
That is
claim.
the advantage authorities get in India.
55,000 and more.
Yes.
Only one person has problem, and I tell you, lordship,
She is entitled to relief for all the 55,000.
If it is, yes. Now, my lord, it says new modalities in prescribed manner. My lord, what is the new modalities? We have integrated the whole grip system, online submission, as well as the physical. Now, so for the physical part with the prescribed manner. Now, what is the physical part with the prescribed manner? That I have stated the which way it is to be done. So it is there. It is
What do you mean by prescribed manner?
Prescribed manner is that now the person needs to go to the rent control office, show the last challan, because he has already submitted an affidavit which is scanned with the system. Now we match with that. The last challan we say, we endorse it. With that endorsement, that person goes to the bank. Since we have integrated with the bank.
That's for a fresh challan, fresh deposit.
Yes, the rent deposit. He goes to the.
How do you deal with those documents being manufactured?
No, I'm coming. It is not. I'm showing. With confidence, I am submitting before lordship. I'm telling you, lordship. Now, this is the prescribed manner in new
You also submitted with confidence on the last occasion. That was the premise of this order.
I am showing the lordship. I'm just kindly giving, because it has lots of technicalities. I'm showing to you, lordship, because I was also got confused initially. Now, my lord, their point is that they will not allow, or they will not.
See the time now also. It just exceeded by 1
I need
minute.
some time, because
No, it was 420 previously. Yes.
And now it's 21. So, my lord, now what they are having the problem, they want that old method to be continued, but it is not possible, because for the transparency, we have this prescribed manner and new modalities. We have kept this physical submission. Now the next, Liberty is given to the petitioners to move the appropriate forum court in the event any default in compliance of the statutory provisions has occurred in the meantime due to technical flaws in the system. This court has not entered into the merits of such issues at all. So my humble submission, respectfully, I submit whether this contempt application is at all maintainable or not, because your lordship has categorically stated in the order any default for compliance of the statutory provisions. My learned friend has shown 21 has been violated, for which your lordship has given them the liberty to go before the appropriate forum. All the subsequent
Not getting
events.
the point, Mr. Shah. He has pointed out that when this order was being passed, you placed a report before the court. That report itself was faulty, which now that's why they are saying in the contempt application it was a fraud practiced upon the court. This report was faulty.
Yes.
And now you're trying to justify that by further faulty documents, by further manufactured documents. Why manufactured documents? Because these documents are patently contrary to Section 21 of Premises Tenancy Act
I tell you.
and Rule 9(4). Because you cannot take these after there are 15 days slots in Section
Yes.
21, which you know very well.
Yes. There are,
Now, after 5 years, this cannot be done.
I'm telling your lordship. Then there are two issues regarding the alleged manufacturing documents and the 15 days. My lord, so far the 15 days are concerned, I have categorically stated with all
This prescribed rules does not mean your prescribed rules. The prescribed rules are there already. Statutorily, those
Yes.
rules are there under the
Yes.
premises tenancy rules.
we have integrated with the digitalization that I'm showing to your
Whatever
lordship.
integrated digitalization, these are
Yes.
sound very nice, but how have you
My lord,
implemented?
today, even the toll tax is being taken online. So,
Don't
my
teach
lord,
us
we
about
have-
toll
No,
taxes.
I'm not
We know
saying-
very much about toll
I'm
taxes,
showing you,
how
lordship.
they are taken, how they are
Kindly-
litigated upon.
Yes,
We
yes.
know very well.
My lord, kindly see how we have done it. My lord, page 30, which was alleged that it is manufactured. It is not. My lord, this is this. Kindly tally it with the reports. Report also we have.
Please tally it with the statute, Section
I'm just
21.
showing it because they have.
How can you accept this deposit
I'm
in
t- This is a
2020?
specimen copy. I'm showing to your lordship.
What specimen copy?
I'm showing to your
Have you
lordship.
stated these are specimen copies? Let
No,
me see
no,
that.
we are showing. No, it's not.
No, let me see your stated it's a specimen
Yes,
copy.
no,
You are
it is
so
not there.
smart. Let me see.
No, it is not there. I'm showing. I'm explaining, your lordship. My lord, kindly take the.
No, you have to
report.
explain right now where you have stated these
I-
are specimen copies. Show me that.
Yes. Kindly come.
We are not joking with you.
No, my lord, I'm explaining.
Show me where you have stated it's a specimen copy.
From the documents I can show.
No, from your average show, these are specimen copies. You have stated photocopies of the relevant challans are annexed herewith,
Yes.
which is practicing fraud upon the court again.
Kindly appreciates one thing.
I don't appreciate of this. I'm sorry. This is cheating in the court, practicing fraud upon the court. You are saying specimen copies. These are actual challans you have annexed.
Kindly, my lord. Kindly.
This is not your drawing room, sir. Your tone of voice won't make any difference. This is not a question of specifying your pet. This is a court of law.
Sorry, my lord, if I have offended your.
No, not you, your client.
My lord.
Photocopies of the relevant challans, and you are submitting merely before the court boldly. I am confident on it. These are specimens.
I'm sure, my lord,
Specimen. Let us come to the specimens first.
I have.
No, your other concern leads to later. First come to this challan.
I'm showing.
Come to page 31st.
Yes, my lord. It is my fault if I have drafted.
Come to page 31st.
Yes, 30, my lord. I'm at 30.
Show me that this is in compliance with the statute. Enough of this. Over smartness.
I'm sorry, my lord, if it has.
Show me from this statute.
I'm showing, my lord. My lord, may I take just instruction, my lord? One.
No, what instructions? Your limits of argument. You said you are confident. Prove it from this.
Page 7.
Mr. Shah, please prove it from page 30. This is in compliance with the statute. Please keep your over smartness outside the courtroom.
I'm sorry, my lord, if I've offended.
Your sorry won't do. I will not hesitate to send you behind the presence also, Mr. Shah. Don't ever make the mistake of taking a joke with the court. Don't be overconfident before the court of law, any court of law. How dare you? You're trying to pacify the court. I'm your pet. Please come to page 30. Show me it's in compliance with the statute. You're so confident on the statute. Please give me a copy of the section 21 of the Premises Tenancy Act. Give me a copy. Read it out. Show me it's in compliance with that. Show me, Mr. Shah, it's in compliance. Please read out section 21 first. For all present in court to hear. Read out section 21 first. You are so confident.
Deposit of rent by tenant. Section 21.
It's not a shire you are reading. Read it out properly.
I'm reading. Deposit of rent by tenant. Section 21(1), where the landlord does not accept any rent tendered by the tenant within the prescribed period, the tenant shall remit the rent to the landlord by postal money order within 15 days of such refusal. Where any tenant remits rent to the landlord by postal money order within the prescribed
Not
period.
money order, it's a money order.
It's money order. my lord.
It's
I'm just-
obsolete. You're in digitalization age, so it's obsolete probably, but money order is still there. In
Money
this
order within the prescribed period, and it is returned to the tenant by the postal authority as undelivered, either on account of the landlord having refused to accept the payment thereof, or for any other reason. The tenant may deposit such rent with the controller. I'm just
Read it out.
I'm not just
Please complete it.
well, my lord. Kindly, just give him. I'm just not feeling well, my lord. Kindly, just give me a moment, my lord.
Take your seat. Take your seat. Come prepared tomorrow, Mr. Shah. You're not well today. I'll take it up tomorrow.
Just I'll do it, my lord.
I'll take it up tomorrow. Cannot be at the expense of the health of a council.
No, my lord. I'll try to assist your lordship, my lord. I'll just. I'm sorry. I was feeling.
Act order record করে দিচ্ছি। Although hearing comments on the contempt application, due to paucity of time, the same cannot be concluded today. Let them attest and adjourn till tomorrow. Mr. Basaha, please come prepared.
My lord, I'll show.
And this is nothing against you.
No,
But
I
you have to
understand.
be when you are confident before a court of law, Mr. Shah,
Yes,
be confident on the facts, come and argue. Be confident.
Yes,
I want you to be confident. I'm not trying to demolish your confidence, Mr. Shah,
Yes.
but be confident on the right things. This is a contempt application, and we are tending to forget what the contempt is because of our toothlessness, because we are not sufficiently strict on contempt. I'm telling you clearly, Mr. Shah, please come prepared well in a contempt application, and if I see some senior over you tomorrow, then I'll send both of you to prison.
I'm led by Mr. Government Peter in this matter.
No, no, you will have to
Fine.
argue.
I will.
You will have
I
to argue tomorrow.
will.